Okay, mayong bantag Dean Elaine, Attorney Christian, and everyone who is with us this morning. Mayong bantag sa tanan. Good morning, marinaga sa indong gabos. Let me share with you my screen. Pwede po ba akong mag-screen share para makita nila yung aking PowerPoint presentation?
It's okay na. You can share.
Okay. So, as I already said, we are talking about critical areas in labor relations law. So, okay. Ayan. Okay, so sabi nila, we started the prayer and that's good. Sabi nila, lawyers are the most prayerful of all the professionals, no? But there's a prayer written by a lawyer himself. Sabi nila, Lord, grant that I may be able in argument, accurate in analysis, strict in study, candid with clients, and honest with adversaries. No? Somehow kasi in our desire, some lawyers in their desire to win their cases, they resort to some dishonest means. No? Extra honest daw. Okay, at sabi nila, bihira na raw ang tapat ngayon eh. Parang tanghali na lang ang tapat. Anyway, sit with me at my desk and listen with me to my client's plaints. Read with me in my library and stand beside me in court so that today, I shall not, in order to win a point, lose my soul. That is if you believe you have a soul. Because if you don't, that is immaterial. Well, ang sabi po sa Bible, you shall not oppress the hired servant who is poor and needy, whether he is one of your countrymen or one of your aliens who is in your land or in your towns. So even the Bible calls for protection of workers. No? At yan naman ang essence ng ating constitutional provisions on labor. And according to a former vice president of Apple Corporation, everyone talks about building relationship with your customer. So probably you have to think of building one with your employees first. So nowadays, ang laging tanong ng mga empleyado, okay lang ba yung no work, no pay policy? Well, sad to say, even the Supreme Court has affirmed that policy, no? That if there's no work, neither should you be paid. Kasi hindi naman charitable institution daw ang mga employers. But we also have to be human in this areas, no, in these times of crisis. But anyway, so as said already, all our discussions would center on this book, Labor Laws and Social Legislation. Ay kapangalan ko yung author. Even my students have been using that, but I have never required them to buy the book. At never ko silang pinilit. So all my students would know that. Ang sinasabi ko lang palagi, you can use any book that you want, but there's a book written by someone whose name is like my name. You're not required to buy, but all the test questions and the recitations will be taken from that book. So may option kayo. Anyway, so ano ba labor? Well, sabi na, labor simply means physical toil. Especially if it is done exchange for wages, di ba? So, however, it may refer to a particular social class. But in labor laws under Philippine situation, we have labor standards. So practically, that is books 1 to 4 of the labor code. Kaya lang yung book 4, alam natin na there have been several amendments, so hindi na siya sinasama sa bar exam. No? And then of course, pag sinabi natin labor standards, these are the minimum requirements that no employer can give a benefit lower than what is required by law. And then of course, you have labor relations. So wala akong kinalaman yung picture sa kanan nakikita ninyo. So ang coverage naman yan ay books 5 up to book 7. So it governs the relationship, that's why it's called labor relations, between the employer, the employees, and of course in relation to the government regulation. And of course, you also have social legislations. So these are laws, rules, and regulation that promote the welfare of all the sectors in the society. So all labor laws are social legislations, but not all social legislations are labor laws, because there are laws that promote the welfare of a particular sector of the society, but not necessarily a labor law. So, ano natin yan, no? Ayan. But all labor laws are social legislations. Okay. So, bar exam question in 2006, why do we need to know or to realize, to understand previous bar questions? ay sometimes kinokopya lang ng mga bagong examiner. Eh. Diba? If you would try to look at the current bar exam questions and the previous questions, you would realize na parang nangopya lang, no? Ayan. So what is the purpose? That's why sabi nila, even in the art of war, you have to know your enemy. Knowing your enemy is half of the battle won. Well, hindi natin enemy yung mga bar examiners. But if you know how the questions are phrased, how the questions are asked, you're familiar with the way questions are asked in the bar, it would be easy for you to answer them. Diba? Kaya make it a habit to answer previous bar questions. Okay? Pwede nyo naman i-download yan. You need not buy a compilation. Pero mas madali kung bibili kayo, compile na eh. But you can download the compilation for free. Dahil ito sa era natin, napakaganda. Dahil you have Google. No? Sabi nga nung nanliligaw sa babae, sabi niya, Google ka ba? Sabi naman ng babae, bakit? Kasi natagpuan ko sa'yo lahat ng hinahanap ko. Ayan. Kaya sabi ng babae, Yahoo. Anyway, so we have constitutional mandate. There are several provisions in our constitution. These are purely reading matters, no, pertaining to labor. Sinasabi niyan, the state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. Diba? And the preference for Filipino labor. That's why kontrolado yung pagpasok ng mga foreigners sa atin to be employed. Exceptions yata yung mga pogo. Anyway, so and the good constitutional mandate for the protection of workers could be found in Article 13, Section 3. Afford full protection to labor, local and overseas, organized, unorganized, etc. And of course, guarantee the rights of all workers to self-organization, peaceful concerted activities, including the right to strike in accordance with law. Later on, you would realize that the right to strike is not a constitutional right, despite the fact that it is in the Constitution. It is a mere statutory right. Why? Because the Constitution itself says, including employees. Because you have to realize that what the law provides is only the minimum. So it's for the employer and the employees union and to an agreement that would be both parties. Okay? Of course, ba ang basis ng labor laws? Sabi natin, powers is the most comprehensive, least limitable of all the power, police power in labor. In labor standards, you can see it in Article 128 of Labor, because the Secretary of Labor is duly authorized representative, and that means regional director could visit, have access to the businesses, could have access to employers' records and premises at any time, day or night, as long as work is being. So Article 278 of, in his opinion, there is a strike or an impending strike or lockout in an industry indispensable, the Secretary of Labor and Employment may assume jurisdiction. So that is a manifestation of the exercise of the state police power. Strike ka, basically you do not want to work. And then here comes the Secretary of Labor, he would assume jurisdiction. No? At pagka nag-assume siya ng jurisdiction, the net effect is for you to go back to work. No? You have to go back to work, that assumption of jurisdiction order. Okay? Now, you also have social justice. Right? Well, social justice ay napakahaba ng definition in the case of Kalalam versus William. But where do we see the operation of social justice in labor, of the labor code? That in case of doubt, the construction must be resolved in favor of labor, but only in case of doubt. Remember that case of PLDT versus NLRC. This is not intended to counten wrongdoing. You cannot invoke social justice, you can only invoke it if you are deserving according to the Supreme Court. We proceed to the NLRC. No? So as we see, there was an amendment, Public Act 9347, at itong amendment na ito, dinagdagan yung number of commissioners. Appointments to the NLRC, to continue, pasensya na sa interruption, Talagang may mga bagay na kailangan nating pagtiyagaan kung gusto natin makuha yung gusto natin, di ba? Ayan. So appointments to the NLRC are not subject to the confirmation of the Commission on Appointments. No? You have that case of Calderon versus Carale, that appointments to the NLRC need no confirmation from the Commission on Appointments. Now, of course, important ito as regards jurisdiction. Okay? So yung jurisdiction of the labor arbiter, of course, you have unfair labor practice. We'll define that later on. Then you have termination disputes, of course, illegal dismissal. You also have claims for wages, rates of pay, but you have to remember that you can only file these cases, wages, damages, and so on, if there is an actual claim for reinstatement. Because if you do not have a claim for reinstatement and you are just claiming monetary benefits, the jurisdiction does not belong to the labor arbiter. Let me clarify that. You have to accompany your claim for wages, rates of pay, hours of work, because the original jurisdiction belongs to the regional office under Article 128 pag labor standards. So how do we submit that to the jurisdiction of the labor arbiter? If you accompany your claim with a claim for reinstatement, because it is now converted into a termination dispute. In other words, illegal dismissal na ito. Okay? Kasi pag wala yung claim for reinstatement, the proper tribunal is the regional office, not the labor arbiter. Okay? So hindi concurrent ang jurisdiction nila dyan. Now, cases arising from 264, that is now 279, because as you know very well, the labor code has been renumbered way back 2015. So yung 264 dati is now 279. Ano ba yan? Mga prohibited activities that are committed or violated in the conduct of a strike or lockout. Okay? Then of course, you do not file these claims before the labor arbiter, employees compensation. So ito yung mga work-related accidents, you file it with the SSS or the Employees Compensation Commission for work-related accidents, injuries, or death. And then claims about social security, yung mga ayuda ng social security, ayuda means help or tulong, you go to the social security system, SSS. And then of course, Medicare. Wala naman tayong Medicare ngayon, di ba? It's now PhilHealth. Despite the many allegations of irregularities, nandyan pa rin naman ang PhilHealth. Sabi nga, if I remember former President Erap, sabi niya, you are unfair to me, especially the media. You have so many allegations against me. But you did not present even a single alligator. Okay. Then maternity benefits. You do not file a claim for maternity benefit with the labor arbiter. You file it with the SSS kapag ka ikaw ay private sector employee. And then all other claims arising out of employer-employer relationship, including ito daw sa domestic or household service. Again, we have to amend this provision of Article 224 because there is already Batas Kasambahay, Republic Act 10361, putting all labor-related issues between the kasambahay and his or her employer under the jurisdiction of the regional office. So you do not bring that claim of a kasambahay before the labor arbiter. So lahat regardless of the amount, because of Section 37 of Republic Act 10361. Okay? So jurisdictional issue dito, regardless of the amount of the claim. Kasi pag above 5,000 nakalagay dun sa Article 224, the jurisdiction will now be to the labor arbiter. Less than 5,000 sa regional office. But if the employee involved is a kasambahay, regardless of the amount, the jurisdiction belongs to the regional office and not to the labor arbiter. Your basis is Section 37 of Republic Act 10361. Okay? Now, as to the power of the commission, ito na yan, promulgate rules and regulation. I just have to remind you that the commission does not sit and bank. Okay? So it does not sit and bank. It decides cases by division of 3. Okay? Now, when does the commission sit and bank? Only on 2 instances. 1, to promulgate rules and regulation. And 2, to to recommend the extension of the term of office of a labor arbiter or a commissioner or the chairman. Kasi ang kanilang term of office, alam natin pare-pareho, di ba? From the time they're appointed during good behavior, but ang dami pa nila dyan, until they reach the age of 65. 65, not 70. Unlike in the judiciary, it is 70, no? So, but sa NLRC, 65. But upon the recommendation of the Commission and Bank, the President may extend the term of office of the arbiter, commissioner, or the chairman. But without such recommendation, the President cannot extend it. So the recommendation must be done by the Commission and Bank. Now, as to the contempt powers of the Commission, the labor arbiters, it is both direct and indirect contempt. There's no distinction. Kasi nagkaroon ng issue dito because in the past, there was that case of Listana versus Land Bank or Land Bank versus Listana saying that quasi-judicial bodies do not possess indirect contempt powers. So puro direct contempt lang sila. But in this case, according to the court, clarifying the provisions of former Article 218, now Article 225, the NLRC, the commissioners, including the arbiters, have both direct and indirect contempt powers. Okay? So walang distinction yung batas eh. Now, sometimes you will get a writ of execution. And the employer has applied for receivership or rehabilitation. So what happens to your writ of execution? According to that case of Rubber World Philippines, it is suspended, okay, until such time that the company is rehabilitated o na-revive. So doon ka na maningil. Okay? O, pag namatay, gagawin mo. Well, following the corporation code, meron siyang 3 years to wind up the operation. That's the time you enforce your writ. Otherwise, you cannot enforce the writ of execution. Okay? Suspended yan. Now, Article 227, technical rules are not binding. Okay, so the purpose of enforcing technical rules of procedure is to aid in the speedy disposition of cases to attain justice. They're not intended to hinder the attainment of justice. But sometimes there are lawyers, no? Not many of them, who resort to technical rules to stifle or to hinder the resolution of cases. So technical rules in labor are not binding, but remember, only up to the level of the commission. When you reach the Court of Appeals, we are bound by technical rules of procedure found in the rules of court. So susunod dito yung appearance and fees, di ba? So technical rule, only lawyers are allowed to appear before the arbiter, the NLRC. Okay? But even non-lawyers are allowed to appear if they represent themselves or they represent their organizations or members thereof. So dalawa ang nakalagay sa Labor Code. That was a subject of the bar question in 2016. Ayan. And then of course, the Supreme Court added one more, letter C. Okay? So jurisprudence lang ito because in the Labor Code there are only 2 exceptions on the appearance of lawyers. So he's a duly accredited member of a legal aid office or authorized by the Department of Justice, the Great Bar of the Philippines, etc. So those are the instances in which non-lawyers may appear. No? Kaya lang pag hindi ka lawyer, huwag ka namang maningil ng attorney's fees. Only lawyers are allowed to collect reasonable attorney's fees. And in your legal ethics, I know you have mastered that. There are 2 concepts of attorney's fees, di ba? The first concept is the ordinary concept, and that is the basis of which is employment. You engage my services, then you pay me as your employee. Okay? And the extraordinary concept, what is that? That is in the form of damages. So when you win a litigation, you are awarded attorney's fees. So extraordinary concept yan. Diba? Okay. So whatever it may be, if you are not a lawyer, do not collect attorney's fees. Only lawyers are allowed to collect fees. And if you become lawyers, you have to look good. Tingnan niyo yung mga lawyers na kasama natin dito, si Attorney Elaine, Attorney Christian, they look good. We look good. Why? Yung appearance ang binabayaran. Diba? So if you don't look good, hindi maganda ang appearance fee mo yan. Ayan. So to give you an idea, paano ba ang flow of cases in the NLRC? So una, nag-file ito, look at this diagram that I am presenting to you, nag-file yung laborer ng kaso. Okay, whatever the case may be, for as long as it is within the jurisdiction of the labor arbiter. Now, even if the case does not belong to the jurisdiction of the labor arbiter, the case would not be dismissed. That's the beauty of Republic Act 10396, reviving Article 234 of the Labor Code. What is that? Mandatory conciliation. Okay? So even if the body where the case was filed has no jurisdiction under the law, it shall not dismiss the case. Rather, it would conduct SENA. Ano ba yung SENA? That's mandatory conciliation, single entry approach. Yung mga nagtatrabaho sa labor, familiar kayo dito, no? So, mandated by law, Republic Act 10396, that the SENA would be conducted within 30 days. If the parties could agree, well and good. But if the parties could not agree, then they have the officer conducting SENA should refer it to the body having jurisdiction. Okay, so assuming hindi sila nagkasundo, now it would be referred to the labor arbiter. The labor arbiter under the law has to resolve the cases within 30 days. 30 days from the time the case is submitted for resolution. In other words, nag-agree na yung mga parties, natapos na yung mga pleadings natin, it is now submitted for resolution. No? Just like in the court proceedings, when you say you offered your evidence, no formal offer of evidence, and you rest your case, the other party has also rested its case, then the court would say the case is submitted for resolution. Nung tatakbo yung 30 days, no? Gagawa ba yan? Aba, maraming may sipag na arbiter dyan. But in my experience, that's 30 days and 1 year. Okay. Now, pagka migrant workers, OFW, that's not 30 days. It's 90 days. Bakit mas mahaba? No, mas maiksi. 90 days from the time the case is filed. Okay? So mas maiksi yun. Kasi from the time of the filing of the case, you count 90 days, dapat may resolution ng labor arbiter. Okay. So may resolution si arbiter. Of course, lawyers would always appeal. Di ba? Kaya nga, lawyers never die. We just lose our appeal. Ayan. So mag-a-appeal ka. And the appellate body is the NLRC. Of course, there are requirements which we will discuss later on para ma-perfect yung appeal natin. Okay, reminder, do not file a notice of appeal anymore. Kasi 10 days lang yan, calendar days. You file immediately a memorandum of appeal within 10 days. Okay? Hindi ka tulad sa korte, may notice of appeal ka pa. And based on the amended procedure, all periods there are calendar days. Diba? So wala na tayo yung sinasabing mga anong days yan. Basta calendar days lahat yan to avoid confusion. And remember, whether in labor or in court, importante ang mga period. Ang problema natin yan pag na-delay, no? Kasi madi-dismiss eh. Okay. So, natalo yung appeal. You do not go immediately up. You file a motion for reconsideration. Okay? Why a motion for reconsideration? Because the mode going to the Court of Appeals is Rule 65. You have 60 days. And according to the Supreme Court, you can only use the remedy of certiorari under Rule 65 if there is no plain, available, or speedy remedy under the ordinary course of law. Eh kung hindi ka nag-MR, you still have a remedy. So you cannot avail of the remedy of certiorari. It will be premature for failure to exhaust all administrative remedies available to you. Okay? So 60 days yan, ha? Special civil action on certiorari. So Supreme Court yan. Court of Appeals muna because of that case of St. Martin Funeral Homes versus NLRC. Okay? I always mention that case of St. Martin Funeral Homes versus NLRC kasi ang abogado ng complainant, itong si Benvenido Aricayos, ay none other than si Wastinian Office of Legal Aid, of which I used to be a director of our Office of Legal Aid Advertised Fund. Anyway, so if you want to stop the enforcement of the order of the NLRC for certiorari will not stop the running of the period. Okay? So, makakapagpa-execute yung nanalo sa baba. That's why, pag ang employer natalo sa arbiters level, natalo sa NLRC, you will file a petition for certiorari it is a must that you ask for a TRO under Rule 58. Ask for an injunction. Okay? Why? Kasi pag hindi nag-issue ng injunction, TRO, yung winning litigant can execute the order. Because the petition for certiorari will not stop the running of the period. So magiging final na executory, you can execute even pending appeal. Okay? But medyo mahirap-hirap kumuha ng TRO ngayon. Ha? You have to convince the Court of Appeals that the remedy is available and you deserve the remedy of an injunction dahil may mangyayari sa iyong irreparable or grave injury if an injunction is not issued. Okay. So from the Court of Appeals, assuming natalo, you go up to the Supreme Court. Okay, pa rin ang motion for reconsideration before the Court of Appeals before you can go to the Supreme Court. Okay? Going to the Supreme Court, you would not use Rule 65. It is just an ordinary appeal. So petition for review on certiorari under Rule 45. And you only have 15 calendar days. Okay. And the Supreme Court, based on the Article 8 of the Constitution, has 24 months to decide the case that you have filed. Okay? But remember, the 24-month period is not mandatory. It's directory. It start, I do not know. Nobody knows. Only God knows. Okay? So yan ang case flow natin from the arbiter up to the Supreme Court. Now, if the appellant is the employer, so may monetary award yan kasi si employer ang natalo eh. Okay? You have to post a bond, whether cash or surety bond. Of course, babayad mo yung cash equivalent to the monetary award. Di ba? Ang sabi ng CODAL, exclusive of damages and attorney's fee. Kailangan isama mo na rin yun. Ha? Okay. So pag wala kang cash, you post a surety bond. Ay ano ba yung surety? Sabi lang, pag hindi ka malas, surety ka. Ayan. Okay. So surety bond, na kukunin mo sa isang bonding company accredited by the NLRC. Otherwise, your appeal will not be perfected. Okay. So siyempre, magbabayad ka ng appeal fee. Under the 2011 rules, it's 500 pesos. At ibabayad mo yan dun sa UCPB, ang bangko ng NLRC. Okay. Then of course, it involves reinstatement. Take note that the award of reinstatement is not only immediately executory, it is self-executory. You do not need to ask for an injunction. You do not need to ask for a writ of execution to execute that order of reinstatement unless may nakuha kang injunction. Di ba? So nakuha ng injunction sa employer, hindi siya makapag-reinstate dahil may injunction eh. But hindi ini-issue, very rare if there is. Very instance, a court would issue a TRO to stop the implementation of an order of reinstatement. But if there's any consolation, the employer may reinstate the worker according to his means. No? Ano yung means na gusto niya? At the option of the employer, take note of the CODAL provision. Reinstate the employee on physically or on payroll. Ang problema natin dito, pag physical reinstatement, hindi mababalik niya sa trabaho. Kaya nga kita tinanggal, ayoko makita pagmumukha mo. Hindi may option ka, reinstate the employee on payroll. So pag ni-reinstate mo yung employee on payroll, di pasuswelduhin mo siya without him working for you. So he's not doing any work. Doon ang problema. Kasi kapag ka na-reverse yung order of reinstatement, in-reinstate mo siya in payroll. Okay? And then, wala siyang ginagawa. Sitting pretty siya sa bahay. Hindi nga siya work from home kasi wala talagang work eh. So, pinapasweldo mo siya. And then the order was reversed. Tama pala na tinanggal mo siya. Can you recover the money that you paid him for his salary while the case is pending? The answer is no. Procaro versus Philippine Airlines, no. The employee is not required to reimburse. Okay? And that was repeated in the case of Garcia versus Philippine Airlines. Huwag nyo nang paniwalaan yung lumusot na kaso noong 2007, Genuino versus NLRC, na pinapa-reimburse. Eventually, it was reversed by the Supreme Court, and the ruling now is Garcia versus Philippine Airlines, that even if the order of reinstatement was reinstated merely in payroll, so he received his salaries without doing any work for the employer, then you cannot ask for reimbursement. Ito ang sabi ng Korte Suprema in that case of Garcia versus Philippine Airlines, the social justice principles of labor outweigh or render inapplicable the civil law doctrine of unjust enrichment. Okay? So walay reimbursement. So paano na ibinayad natin? Wala na, di mo na makuha yun. Ha? Okay, so execution, of course, sabi ng Korte Suprema, one end. Lahat may katapusan. Kaya walang forever, di ba? So lahat na may forever, naghihiwalay din yan. Only time will tell. Okay. Why? Hindi ka naman daw kasi magiging sapat sa isang tao na ang iba ang hinahanap. Okay. Sabi pa sa mga Cebuano, hindi ka naman daw maigo sa usa ka tao na ano ba yun? Lain ang ihanap, no? Okay. I do not know if my Cebuano is correct. Ayan. Iba hinahanap niya, so hindi talaga magiging sapat. But anyway, so it will come to an end. Execution. The execution of a judgment may be made motu proprio. Okay? So pag sinabi natin motu proprio, hindi mo kailangan mag-file ng motion for execution. However, huwag niyong antayin yan. Sabi ni arbiter, ba't ako mag-execute yan? Yung abogado mo nga ayaw mag-execute eh. So you can file an ordinary motion for execution within 5 years from the time the case has become final and executory when you receive an entry of judgment. Okay? So nagkaroon ka ng entry of judgment, the case is final and executory, you have 5 years to execute that. Eh, hindi mo na-execute within 5 years. So what do? You still have another 5 years to file an independent action for revival of judgment or for execution. But you have to do that within another 5 years because the law says, and it was affirmed by jurisprudence in 2014, that under the code, time of the finality of judgment. If you cannot execute within 10 years from the finality of judgment, you cannot execute anymore. So what do? Please do not execute your lawyer. Okay. Tatrabaho lang naman siya. Now, another jurisdiction, this time, the BLR. So if you have questions, meron tayong chat room, so you can just put there your questions and I will answer your questions later on. Okay. So BLR, the Bureau of Labor Relations. Dalawa lang ang jurisdiction yan. Una, inter-union dispute. Okay, pag sinabing inter-union, there are 2 or more unions having conflicts, no? That's why ang mga examples ng ating inter-union dispute, you have certification election, consent election, run-off election, and under the new rules, rerun. Okay? Yeah. Then of course, you have intra-union dispute. When you say intra, it means internal. Okay? Parang intra-union. Sorry. So intra meaning inside. Okay? So kayo-kayo lang sa union nag-aaway-away. So si employee A, employee B belonging to the same union, nagkaroon ng election, tumakbo si A ng presidente, tumakbo si B ng presidente, nanalo si A, si B, dinaya. Okay? So dinaya. Sa Pilipinas ganyan, may nanalo, may dinadaya. Walang natatalo. Okay. So ngayon, anong gagawin nung nanalo? Ano natalo? Eh di magpapile siya ng election protest not with the COMELEC but with the BLR. BLR, no? Okay. And of course, all other grievances, wala nang jurisdiction ng BLR dito. Bakit? It is now under the jurisdiction of the grievance machinery, which we will discuss later on, and voluntary arbitrators under the Labor Code. And some of the arbitration, mediation, conciliation activities of the BLR are now transferred to another body, and you call that National Conciliation Mediation Board, NCMB. Okay? So, now, you can enter into a compromise at any time, at any stage of the proceedings. Kaya lang, the compromise, execute ka ng waiver or quit claim. So, noong 2016, question number 1, 5 points. What are the requisites of a valid quit claim? Diba? So, napakasimple ng tanong. And that could be answered if you have read this jurisprudence, no? That not all quit claims are invalid per se or in themselves. But if it is against public policy or there is clear proof that the waiver was wangled from unsuspecting gullible person or the terms of the settlement are unconscionable. So the court may still inquire into the validity of the waiver and quitclaim. But generally, the courts would respect the contents of your waiver and quitclaim, okay? Unless otherwise is shown or proven. Liwanag tayo dyan, ha? This Republic Act 10396. I've been mentioning this earlier na ito yung dahilan kung bakit nagkaroon kayo ng single entry approach. Although nauna pa yung single entry approach, no? Na all labor disputes must be submitted to this proceeding, the single entry approach or SENA. But within 30 days, there is a mandatory conciliation mediation process with the hope that the dispute would be settled. If there is a settlement, well and good. Minus ang trabaho, minus ang stress. But if it is not settled, then that's the time we file cases, no? Magpo-proceed yung kaso. Ayan. Then of course, what about the contract bar rule? The contract is your CBA. So the contract bars any petition for certification election within 5 years. So ang requirement, if you have a CBA, collective bargaining agreement, you file it with the BLR. Because if you do not furnish BLR a copy of your CBA, the contract bar rule will not apply. So meaning, at any time, pwedeng i-disturb yung CBA ninyo. Okay? Yan, advice ko palagi sa mga estudyante ko, kapag kayo ay may bagong karelasyon, irehistro nyo sa BLR para nakakasiguro kayo na within 5 years, walang makikialam kahit nambyanan. Okay? Kasi pag hindi rehistrado ang inyong collective bargaining agreement with the Bureau of Labor Relations, at any time, pwede kaming mag-file, yung mga kalabang unions, pwede mag-file ng petition for certification election. And it is not barred by any contract. So tandaan yan, ha? May bagong CBA, rehistro sa BLR. Now, what is the effect if the CBA is not registered? Valid ang CBA between the employer and the union. But the other unions waiting in the wings will still have the chance to file a petition for certification election despite the existence of your collective bargaining agreement. Okay? That's why filing a copy with the BLR or registering it with the BLR would secure you that no person, no union would disturb your CBA for the next 5 years except during the freedom period. And that is a 60-day period before the end of the 5-year period. Again, period na naman. Okay. So puntahan natin yung mga boring na issues sa labor relations. No? Ito ay boring kasi unang-una hindi naman natin nararanasan ito. Sino sa inyo kung meron man na part ng isang labor union o nagrehistro na kayo ng labor union. Ba? Well, people sometimes are afraid of things they cannot understand. Okay? Ayan. So huwag kayo matakot. Simple lang ito. So kapag meron kang union, irehistro mo. If your union is an independent union, meaning wala kang affiliation, you register it with the regional office. If you're a federation, you register it with the Bureau of Labor Relations. If your independent union is operating in more than one region, let's say you're in Cebu, and then you have another branch or another union, same union but operating in another branch of your company in Iloilo, magkaibang region yan. 6 and 7, no? 7 ang Cebu, 6 ang Iloilo. Then you have to register your independent union with the Bureau of Labor Relations. Okay. Ngayon, tinatamad ka na magrehistro sa BLR. So anong gagawin mo? You just go to a federation and ask the federation to give you a charter certificate. From the time the federation issued a charter certificate, then you will have that legal personality. Okay? Legal personality as a union. You can now participate in certification election. But the federation who issued you a charter certificate has the obligation to report it to the BLR para ma-recognize yung legal personality ng kanyang local chapter. Otherwise, hindi ka makapag-participate dun sa certification election, consent election, or runoff election as the case may be. Okay? Ayan. Now, if your application for registration is denied, you can appeal. Of course, the period to file an appeal is within 10 calendar days from receipt of the notice of denial. If the denial is made by the regional office, appeal must be made to the Bureau of Labor Relations. If the denial is made by the Bureau of Labor Relations, you go to the Secretary of Labor within 10 days. If the denial is made by the Secretary of Labor, your resort is go to the Court of Appeals, but this time you have to use certiorari under Rule 65. Do not go directly to the Supreme Court. Despite the caudal provision that you go to the Supreme Court, it is now deemed amended by the case of St. Martin Funeral Homes versus NLRC that all labor cases, before going to the Supreme Court, you have to go through the Court of Appeals. Why? Observe the hierarchy of courts, according to the Supreme Court, in that case of St. Martin Funeral Homes versus NLRC. Now, if you are to register a federation, walang kinalaman ho itong mga litratong ito, no? Pasensyahan na ninyo, wala lang mailagay. So, if you want to register a federation, you have to submit proof of affiliation of at least 10 locals or chapters. Otherwise, hindi ka marirehistro as federation. Ano ba ang mga federation natin ngayon? Ako marami yan. Yung isa, yung Federation of Free Workers, FFW. Sabi niya, KMU. Oh yeah, federation yan. Kilusang Mayo 1. Diba? Pero ang kauna-unahan palang member ng KMU ay si President Noynoy Aquino. Bakit siya KMU? Oh, KMU siya. Kapisanan ng mga makikintab ang ulo. Ay, sorry ho. Libero lang tayo. Okay. At nasolusyonan na raw yan ng NPA. NPA, nakapilo ka ako. Delikado at nag-take effect na yung napirmahan na pala yung anti-terrorism bill. Solo na siya ngayon. Pag natapos ang publication. Okay. Kung hindi naman NPA daw, BMW. Yung BMW, buhok moving. Anyway, so, now, walang forever. Di ba? Pwede namang ipa-cancel. I-register mo yung union, pwede mong kanselahin. But you have to file the petition for cancellation with the Bureau of Labor Relations. Kasi ang mangyayari dyan, inter-union dispute yan. Okay? One union asking for the cancellation of another union, that's inter-union dispute. Okay? Maliwanag. So, DLR. But you have to be consistent. You can only use 2 grounds. What are the grounds? As provided under 247. Dati 239 ito. When we were studying labor law, yan ay 10 ang grounds. But right now, you only have 2 grounds. Sabi nyo, iba hanggang letter C. Mamaya, paliwanag natin. So, misrepresentation, false statement, fraud regarding the adoption of the Constitution, ratification, everything about the Constitution. Pangalawa, misrepresentation, false statement, fraud in relation to election of officers. So, those are the 2 exclusive grounds that you can use to file a petition for cancellation of union registration. What about letter C? That is exclusive for the members. Only the members can avail of that 3rd ground for cancellation. Okay? Dalawa lang ang grounds ng 3rd party to file a petition for cancellation of the registration of a union. Okay? Now, what about voluntary cancellation? We'll discuss it in a while. Now, collateral attack is not allowed. Okay? If you want to attack the personality of a labor union, you do it directly by filing a petition for cancellation to the BLR. Sabi ni ng union, sir, sa employer, mag-bargain ho tayo. Sabi ng employer, I cannot bargain with you kasi may dayaan daw yung inyong eleksyon. Hindi mo magagawa yan because that is in the form of a collateral attack. You can only file a petition for cancellation as a means to cancel a union registration, but you cannot attack the personality of a union collaterally. Maliwanag po at hindi nagbabago ang desisyon ng Korte Suprema dyan since 2003. So kung may reklamo ka sa isang union, the best remedy that you can do is to file a petition for cancellation before the Bureau of Labor Relations and make sure that you are using the grounds provided under 247. Okay. Now, puntahan natin yung voluntary cancellation by the members. Because even the members may want to cancel their own registration or the registration of their own union. But remember, the right to unionize is a constitutional right. So yung mga miyembro gustong ipakansila, anong dahilan, di ba? Sabi nila, it's not you, it's me. Okay. Ayan. So kailangan natin ng stringent requirements to be complied with. Ito, may General Assembly, lahat ng mga miyembro naman yun. And there must be a voting process. So magbobotohan tayo at least 2/3 of the general membership. Hindi po pwedeng, the meeting must be called specifically for the cancellation of your union registration. Otherwise, that would be invalid. Why? Sabi ng presidente, halika kayo mga kasama, mag-inuman tayo. Bawal pa pala. No? O yan, kasi birthday ko. Parang si General Sinas, ha? Manyanita. O pagdating doon, nung magkalasingan na, o sinong gustong kansilahin ang ating union registration, taas ang kamay. 100% nagtaasan ng kamay. Ay, that's invalid because the meeting was not called for that purpose, for the purpose of canceling the union registration. Okay? What's the effect? Kasi kung ayaw kong kansilahin yung union registration, hindi ako attend sa meeting. Kasi alam ko yung purpose of that meeting. So you cannot get 2/3. Ang problema, may fraud, may misrepresentation. The birthday party, it turns out cancellation pala. Diba? So take note of that. Mga 50 years na hindi tinatanong sa bar exam yan. Okay. And the labor code is less than 50 years. So what about check-off? As a member of the union, syempre wala namang free lunch, no? Ayan. Libre daw kayong lunch ata ni Asok din Elaine mamaya, ha? Kaya lang e-buffet. Okay? Kanya-kanya kayong pili ng menu na gusto ninyo. Ha? So, libre yan. Okay. So, check-off. Check-off is a process. Nakalagay dyan, di ba? Method of deducting from the employee salary a certain amount as agreed upon. Para saan yung deduction? To answer for union membership fee. So let's say dun sa constitution and bylaws ng union, pag miyembro ka, magbabayad ka ng 100 pesos per month. So hindi na yung union ang mangungulekta individually sa mga miyembro. I-authorize ni union member yung kanyang employer to deduct that said amount. And that process is called check-off. Okay? Yan. Wait, is there a need for authorization? Kasi ano yan may written authorization individually. Why? You go back to Article 113. No deductions can be made from the salary of an employee unless it is authorized by law or he consented to such deduction. Okay? So kaya hindi po pwede na may utang kay employer yung employee, yung sweldo mo, hindi na kita papasweldohin kasi may utang ka sa akin. Hindi pwede yun unless there is a written authorization. So maliwanag ang batas dyan. Alam niyo naman, hindi ito tinutupad ng marami nating mga employers. Why? Well, we have to be familiar with it that in the Philippines, laws are mere suggestions. No? You know, there is a law because everybody is violating it. At I love to always make this as an example. Diba? Nakalagay, bawal tumawid. Hindi yung bawal lumabas. Bawal tumawid. Pero pag nag-comply ka, hindi, wala naman sumunod sa bawal tumawid. Pinalitan. Walang tawiran. Nakamamatay. Metro Manila, familiar yan. Walang sumunod. Pinalitan nila. Walang tawiran. May namatay na. Wala pa rin sumunod. Siguro ngayon, dapat palitan na natin yung mga karatola. Anyway, binabago ang EDSA. No? Lalagay natin para sundin. Walang tatawid. Papatayin. Ano naman sumunod na. Anyway, so yan yung check-up. Okay. Now, what about special assessment? Nangolekta ka na dun sa mga miyembro mo, hindi pa rin sapat. Dahil iba pa lang hinahanap. O hindi pa sapat. Inadequate. I think kailangan natin special assessment. Same requirements would have to be complied with para mangolekta ka ng special assessment only from the members. Kasi sa isang employer, not all employees are members of the same union. Di ba? Therefore, only members of the union are required to pay special assessment and union membership fee through the process called check-off. Okay, what about agency fee? Ayan, iba to, no? Ang agency fee is the amount paid by the non-union members, provided they benefit from the CBA concluded by the union and the employer. Diba? Nakalagay yan dun sa collective bargaining agreement, no? So bayad ka ng agency fee. Ayan. Walang written requirement. Bakit agency fee? Kasi you are making the union your agent in bargaining with the employer. So kaya, magbayad ka ng agency fee para walang free rider, no? Walang mga nakikisakay lang. Ayan. Now, as I said earlier, the right to unionize is a constitutional right grounded under Article 3, Section 8. Ano ba nakalagay doon? Basa. The right of the people, including those employed in public and private sectors, to form unions, associations, and societies for purposes not contrary to law, shall not be abridged. So it goes to show that everyone has the right to join a union. There are exceptions, however. Ano yon? Ang sabi ng Executive Order 180, at ito naman ay included sa inyong bar examination syllabus, under Executive Order 180, there are employees who are not even authorized to join unions. Okay? Ayan yan. High-level government employees because they are serving at the pleasure of the President. So pag hindi nagustuhan ni Presidente ang gawa mo, alis ka na. Di ba? Kung may quarantine at nag-swimming ka with the dolphins, home sweet home. Wala ko sinabi kung sino, ha? Eh, pwede kang tanggalin at anytime. Mag-unionize ka pa ba? Okay? So members of the armed forces, Philippine National Police, mga firemen, jail guards, ito, hindi kayo pwede mag-unionize. Kung may nanonood sa atin at may participant dito ng mga jail guards, members of the PNP Armed Forces, at yung mga bumbero. Okay? Dito nagkakasunog eh. Kasi may sunog na, tatawag ka pa ng firemen. Bakit hindi watermen ang tawagin natin? Ha? Anyway, so mga masisipag yan. Kaya lang bawal sila mag-unionize because of the nature of their work, and it is also provided under Executive Order 180. Okay? Now, employees of international organizations, they are not allowed to unionize. Why are they not allowed to unionize? Because yung kanilang organization may have immunity from local jurisdiction. So what's the use of allowing them to unionize? Diba? Then of course, managerial employees. So itong mga managerial employees na ito, by the way, sa labor relations law, managers do not include supervisors. But in labor standards laws, even supervisors are recognized as managers. Okay, so ano kaibahan? Supervisors may unionize, but managers are not allowed. You go to Article 255 and eligibility of managerial employees. Diba? Okay. So, in school setting, ang sabi dito sa Cainta Catholic School, even the Dean of Student Affairs, ay managerial ang function niya. Kaya hindi siya pwedeng sumama sa faculty union. Okay? Yan ang pinakamagandang posisyon daw sa eskwelahan eh. Dean of Student Affairs. Why? Legal yung affairs with the students. Anyway, so yung mga confidential employees, hindi rin sila pwede mag-unionize. Maaaring hindi sila managerial, maaaring rank and file yan. Like yung sekretarya ng presidente. Hindi siya pwedeng sumama sa union. Bakit hindi siya pwedeng sumama sa union? Eh kasi nga, he or she has in his or her possession information that may be detrimental to the management if revealed to the union. Okay? Then, members of the cooperative. How do you become a member of the cooperative? You put some amount as your share in the cooperative funds. Diba? So, part owner ka na ng cooperative. And then you are hired as an employee. Hindi ka pwede mag-unionize because you are part owner of the cooperative. Are you allowing a stockholder of a corporation to be a union member against the corporation? Of course not. You cannot negotiate, you cannot bargain with yourself. Diba? But the security guards, naman to si Manong Guard. Security guards have the right to self-organization, provided yung kanilang union activities ay directed sa kanilang direct employer. Who is the direct employer? Yung kanilang security agency, the contractor, and not against the employer, the indirect employer under Article 107 of your labor code. Diba? So, contractor-subcontractor relationship yan eh. So dapat dun sila sa kanilang direct employer mag-unionize. Okay. And then, government employees are allowed to unionize. But as was said earlier, you are not allowed to have your strike provided you are covered by the civil service law. That's the case of GSIS versus kapisanan ng mga manggagawa sa GSIS. You are allowed to unionize. But remember, the right to unionize does not carry with it the right to strike. Okay? So, pag covered kayo ng civil service. Eh, ano ba ang civil service? We go back to the main definition of civil service, the coverage of which could be found in Article 9-B, Section 2, Paragraph 1, that civil service embraces all branches, instrumentalities, subdivisions of the government, including government-owned and controlled corporations with original charter. So pag GOCC katulad ng GSIS, that's a GOCC, it should have original charter, meaning there is a law that created it. And what's the charter of the GSIS? It's Republic Act 8291. Okay? So yung empleyado ng GSIS covered ng civil service law, they may unionize, but they do not have the right to strike because they are civil servants. Okay. Now, public school teachers are not also authorized to have their strike because the right to unionize does not carry with it the right to strike. What about managers? Ayan, sabi natin, ang mga managers ay hindi pwedeng mag-unionize. Supervisors may unionize. So dito naghiwalay ang supervisor sa manager. Managers are prohibited by Article 255 to unionize, whereas supervisors are allowed to unionize provided they do not join the rank and file union. Okay? So yan yung ating standard dyan. Now, what is the effect? Ito sana gusto kong iboto sa pagkasenador noon. Ayan, pasensya na. At hindi atin niya sa Google yan. What is the effect of including a non-union, a member of a union who does not belong to the bargaining unit? Of course, mamaya pa natin i-define kung ano yung bargaining unit. Ano? So, assuming a supervisor joins the union of the rank and file. Ang sabi ng Article 256, siya ay deemed removed from the list. Salimpusa lang siya. In other words, pag nakakuha ng benepisyo sa CBA nila, itong supervisors, itong rank and file union, yung supervisor na sumali sa union is not included in the benefits. Why? He does not belong to that bargaining unit. Sumali lang siya. But that is not a ground for cancellation of union registration. You cannot have the union registration canceled simply because a supervisor joins your rank and file union. That's the case of Air Philippines versus BLR. Okay? So anong epekto? Wala lang. Tanggal lang siya dun sa listahan ng mga union members. If ever there are benefits for the union members under the CBA, the supervisor is not included because he does not belong to the rank and file union. Okay. Now, the case of unfair labor practice under Article 258. Not because it is unfair, it is already unfair labor practice. Take note. So unfair labor practice, ang ganda ng definition niyan under Article 219K. If you have your codals with you, read with me. Unfair labor practice means any unfair labor practice as expressly defined by this code. Very meaningful. Diba? Pero sabi ng Supreme Court, it does not give us anything but a mere repetition of the same term. So ano ba ang unfair labor practice? Any activity, to simplify it, any activity of the union or the employer that affects the right of an employee to join or not to join a union. Yun ang correct definition of unfair labor practice. Kasi kung layman ka at hindi ka nag-aral ng batas katulad ninyo, katulad natin, pag naging unfair si employer kay employee A, binibigyan niya ng special favor, si employee B hindi, sabi natin unfair labor practice na kaagad yun. But in reality, teka muna, may kinalaman ba yan sa union activity ni employee B at ni employee A? Kung wala, do not call it unfair labor practice no matter how unfair. Okay? because unfair labor practice has a technical definition under Article 258 of the Labor Code. Never mind Article 219K. Ha? Hindi masyadong magandang definition yan. Okay. There are two aspects of ULP. Okay. Civil aspect. Jurisdiction belongs to the labor arbiter. Okay? At you have to file it within 1 year. Ha? Now, meron niyang criminal aspect. The criminal aspect is under the jurisdiction of the Metropolitan or Municipal Trial Court because the penalty is less than 6 years. Huh? Okay. Now, you can only file a criminal case for ULP if there is proof, meaning may findings a labor arbiter that unfair labor practice was indeed committed by the employer. In the absence of such finding by the labor arbiter, you cannot file a criminal case for ULP. That's a mandatory requirement. Sabi nga nila, a condition sine qua non. That without which, you cannot file a criminal case. That's the reason why wala yata o napakakonti ng jurisprudence on criminal ULP. Kasi if ULP is committed by the employer, kaysa mag-file ako ng criminal case, mag-strike na lang ako because ULP is a ground for a strike. Diba? Okay. What are the unfair labor practices that may be committed by the employer? Well, one of which is the yellow dog contract. Diba? Hindi naman dog si Garfield. So ano ba yung yellow dog contract? It is a contract between the employer and the employee saying that I will hire you, but you do not join a union. I will hire you, member na po ako ng union. Then you resign from the union so that I can hire you. Diba? So why is it called a yellow dog contract and why is it a void undertaking? Dahil yan ang sabi, in my research, ang sabi, yellow is dull or dingy, may represent caution, sickness, and jealousy. Hala, pagkasilosa pala kayo, kayo maninilaw. Silosa ang mga dilawan. Okay? Bakit dog? Kasi no matter how ferocious the dog is, you give him food, a meat or bread, ay babait yan. Diba? Yan nga may mga bomb-sniffing dogs, drug-sniffing dogs. Nagre-reklamo yung handler ng isang K9. Sabi niya, sir, bakit palagi na lang K9? Sabi ng kanyang commanding officer, okay na yan, pagtiyagaan mo na. Kasi aso tayo K9. Kasi pagka K10, pusa na yan. Diba? Okay. So, pusa is K10. Malit na pusa. Anyway, so puntahan natin yung Yellow Union. It is a company union or yellow union. Teka, hindi ito mga dilawan. Ha? Under ILO Convention 98, Article 2, when the employer intervenes or interferes with the organization of the union or dominates the union, that's a yellow union. That's unfair labor practice. Okay? And then what about a runaway shop? Ayan, ito runaway bride yung nakikita nyo. A runaway shop is the situation wherein the employer transfers to another location. Sabi niya, dahil may ECQ sa Cebu, doon muna ako sa Iloilo mag-operate. Okay? Yung pala, iniiwasan niya lang kasi mag-i-strike yung mga Cebuano. Diba? Okay, doon na lang ako sa Iloilo. That's a runaway shop. Para mag-strike man kayo, balak sa buhay nyo, I will still continue operating. Okay? So that's an example of a runaway shop. Or dito sa Metro Manila, medyo mataas dito ang minimum wage. Ayoko na mag-operate dito. Ita-transfer ko doon sa mga regions na mababa ang cost of labor. That's the reason why China flourished. Why? The cost of labor is very cheap. Kasi ang daming tao, ang daming workers, di ba? When the supply is greater than the demand, the price would go down. Okay? Ayan. So kaya, maraming Chinese products. At lahat pala, even those things that would kill us would be made in China. Okay. Pero ayaw nang tawaging Wuhan virus, COVID talaga. Anyway, so let us proceed to blue sky bargaining. Look at the sky today. In our place, it's not blue. So it's low. If the sky is blue, it's very high. It's very high. So blue sky bargaining is the act of making exaggerated or unreasonable proposals. Okay? So yan yung chartered bank versus confessor, standard charter. Okay. Now, what about bulwarism? On the part of the employer, kilala si Lemuel Boulware or Boulware, whatever you may call him, siya ay dating Vice President ng General Electric. Whenever the employees or the union would demand for something, ang sasabihin niya, this is the best and last offer I could give you. Take it or leave it. Eh ano pang gagawin mo? Take it or leave it na, di ba? It's not you, it's me. Kung ayaw mo, edi wag. Di ba? Eh that's unfair labor practice on the part of the employer. Kaya nga tayo nagbabargain so that we could meet halfway. Ibibigyan mo ko ng take it or leave it, eh ano na yan? Di ba? It's no longer bargaining. We cannot meet halfway anymore. Okay. Then, surface bargaining. You go through the motion of bargaining to make it appear that you are complying with the mandates of the law. But in reality, at the end, wala kayong contract, wala kayong CBA. So you have done a surface bargaining. Okay? And that's unfair labor practice. What about feather bedding? Feather bedding is the practice of the union in asking a certain amount from the employer. Sir, bigyan mo ko ng certain amount, gagawin ko ito para sa'yo. After some time, hindi niya naman ginawa. So, nangolekta lang siya. Di ba? Parang Globe Smart at PLDT. Nag-promise na magandang bandwidth, mabilis na internet. Hindi naman ginawa. Abay, feather bedding yan. It is in the nature of exaction. Pero sabi ng union, sir, pipinturahan ko yung ating building. Sabi ng employer, sige, blue. Pininturahan niya ng pusya. Anak ng pusya naman. Will that be feather bedding? That's not feather bedding. Kasi for as long as work is done, no matter how trivial, there's no feather bedding anymore. Yung feather bedding, wala talagang ginawang trabaho, pero nangolekta. Okay? What about a sweetheart's contract? Ay, iba yan. Iba yung sweetheart na yan. Anyway, a sweetheart's contract is a deal between the employer and the union. Kasi alam nyo, you have to visualize, hindi lahat ng members ng union sumasama sa bargaining table. May mga representatives lang yan. Sabi ng employer, I'll give you a certain amount, pumayag ka na sa ganitong kasubuan. So in other words, ibinenta ang kalayaan. Parang si Aguinaldo, malaya na, nananalo na sa mga Kastila. Sabi ni Pedro Paterno, makipag-arrange ka na kay General Primo de Rivera, para babayaran ka, tapos punta ka ng Hong Kong. Parang ganyan. So a sweetheart's contract or a sweetheart's deal is a contract that is against the law. Pero hindi naman lahat ng sweethearts ay against the law. Diba? Ayan. Okay. So 2009 bar exam. Explain the impact of the union security clause to the employee's right to security of tenure. OMG. Ano bang tanong yan? Madali lang yan mga kapatid at kapanalig sa pananampalataya. Una, ano ba ang purpose ng security clause? By the way, a union security clause is a provision in your CBA. Okay? And we'll discuss some of them. A provision in your CBA. So you do not talk about union security clause pag unorganized establishment, pag walang union. You can only have union security clause if there is a CBA. So the purpose is for the protection of the members of the union itself, for the benefit of the members, and for self-preservation. Yun ang importante sa union security clause, self-preservation. Okay? Now, 2015 bar exam. Very recent lang. Distinguish between a closed shop and a maintenance of membership clause. Marami nagalit dito. Ano ba yung tanong na yan? That's a valid question. Okay? So, ano yung tanong na yan? Closed shop. Hindi ibig sabihin na nagsara kasi nalugi na dahil na COVID, nagsarado na lahat. Kawawa naman yung mga employer ngayon. At lalo kawawa yung mga employees. Kaya tayong mga nasa gobyerno, pasalamat tayo dahil ang gobyerno natin may pambayad pa. Okay, even if we are working from home. Okay, so closed shop is an agreement between the employer and the union. As I said, it is in your CBA. So, anong agreement nila? Let's say there are three unions, A, B, C, D. Union A and employer may CBA. So may CBA sila. 5 years yan. Sabi ng closed shop arrangement, the employer will not hire anyone who is not a member of Union A. Pwede ba yun? Oo, pag para i-hire ka niya, dapat member ka ng Union A. That's a closed shop agreement. Okay? Now, what about a maintenance of membership clause? Yun ang tinatanong. So in a maintenance of membership clause, the employer may hire anyone for as long as the members of Union A, yung contracting union natin, will remain members of that same union for 5 years. Why 5 years? That's the duration of the CBA. Okay? Ayan. Now, what's the penalty for violation? Ayan, discharge from employment. Now, you also have union shop. In a union shop arrangement, the employer may hire anyone, whether a member of the union or not. Remember, Union A pa rin yung reference natin kasi siya ang may CBA with the employer. Now, that employee who is not a member of the union, who was hired, is given a certain period of time in which he should become a member of Union A, the contracting union. Liwanag. Pag hindi siya nagmiyembro, tanggal siya. Okay. Agency shop. No one is required to be a member of the union. Kung ayaw mo sumali, di wag. But, if you are not a member of the union, you get benefits out of the CBA contracted by the union, then you have to pay a certain amount and you call that agency fee. Diba? Kasi naalala pa ninyo yung mga traditional jeepney, ano? Ayaw pa yung bumiyahe ngayon. Sasakay. Wala palang pera. Doon sa gitna po pwesto. Kung may nagbayad, mama, bayad. Mama, sukli. Mama, bayad. Mama, para. Hindi na siya nagbayad. Yun ang mga free rider, mga hitchhiker. Diba? Nakikinabang ka for nothing. O, diba? O, magbigay ka ng bayad. So, yun yung agency fee. Okay. And preferential shop. In a preferential shop agreement, an employee is not required to be a member of the contracting union. But if there are vacancy, preference must be given to the employees who are members of the union. So let's say kailangan ko ng ako sa employer, for example, I need a forklift operator. Nakausapin ko si Union A, siya ang kakontrata ko Yun ang may CBA, di ba? O Union A, do you have a member who can operate this forklift? Sabi niya, boss, wala puro driver ito ng karo ng patay. I can hire anyone, even not a member of Union A. But preference was given to the contracting union. Okay? Ayan. Now, ito yung tanong kanina, paano ko naka-close shop ho kami, hindi ko gusto sumali sa union because of my religious belief. Because there are certain religious organizations who do not allow, or probably they limit their members from joining the union. Naka-close shop. Sinagot na ito as early as 1974. No? Members of religious groups may not be compelled to join a labor union because religious freedom is a constitutional right. The same with union membership. So pagkaayaw, huwag pilitin. Masasaktan ka lang Di ba? Pinipilit yung ayaw. Maliwanag yan. Kasi may mga religious organizations na hindi daw pinapayagan yung miyembro nila na sumali sa union. So do not compel them to join even if you have a closed shop arrangement. Okay, so ito yung penalty for violating union membership clause. You can be dismissed provided these requirements are complied with by the employer and the union, asking for the termination of the employee who violated the union security clause. Okay? Liwanag tayo dito mga kapatid at kapanalig sa pananampalataya. Now we proceed to collective bargaining. Ano ba ang collective bargaining agreement? A collective bargaining agreement is a contract. What kind of contract? It is a contract between the employer and the union. Setting forth the conditions, terms of employment for mutual benefit of the employer and the union. Okay. So yan ang purpose ng collective bargaining, di ba? To attain the best possible covenant or terms relating to economic, non-economic benefits. Okay? That's why, as a word of caution, when you bargain, pag nagpa-practice na kayo at gusto ninyong sundan yung mga labor lawyers na katulad ko, and you are for the employees union, bargaining with the employer, you do not go for the minimum. You always set your eyes on benefits higher than the minimum. But not so high. Kasi pag masyadong mataas, baka blue sky. Kasi even if you do not bargain, remember this, even if there's no bargaining, the employer is mandated by law to give the employees the minimum benefits. Kaya nga labor standards ang tawag natin, di ba? If you want to bargain, make sure that you bargain for something higher than the minimum. Otherwise, you're just wasting your time. Okay? Ayan. So what about good faith bargaining? Sabi ng Korte Suprema, there is no test per se. What constitutes good faith bargaining? Just like what it is said in the Bible, di ba? You shall know them by their fruits. Because a good tree cannot bring forth bad fruits. Neither could a bad tree bring forth good fruits. Okay? So pag nagkaroon ka ng CBA, baka nagkaroon kayo ng good faith bargaining. Kung maganda ang CBA. Okay. Now, before an employer bargains with the union, ito yung mga requirement. Possession of majority status. How do you possess majority status? Maaring ikaw nanalo sa election. And we will discuss that later on. Then, what is your proof that you won? Di yung certification issued by the BLR that you won. And then, did you make a demand? Did you send a letter demanding the employer to bargain with you? Kasi kung wala yan, do not expect the employer to bargain with you. Do not ever expect the employer to initiate the bargaining process. Why? Alam nyo, pagka may bargaining, may increase in benefits. New benefits will be given. Sinong employer ang gusto niyan? Diba? Ayan. So, para ka daw ice cream. Bakit? Sweet ka nga, pero malamig naman. Tanong nyo sa mga boyfriend o girlfriend nyo, ice cream ka ba? Bakit? Sweet mo, pero ang lamig mo. Dapat hot ka. Para kang sili, di ba? Mas maganda yung sili. Bakit? Ang liit, pero ang hot. Okay. So, what are the steps in collective bargaining? Of course, maraming stages yan, but take note of publication requirement. That the CBA must be published, not in a newspaper, but it should be posted in at least 2 conspicuous places in the employer's premises. Kailan? 5 days prior to ratification. Okay? Bakit? Kasi for purposes of due process, for purposes of notifying everyone. Because as I said earlier, not everyone participated in the bargaining. Diba? So if you did not participate, how would you know the contents of the CBA? So it should be posted. Practical naman yan. So 5 days bago tayo magkaroon ng ratification. Ratification through secret balloting, lahat ng empleyado in the bargaining unit, whether members of the union or not, they would vote because they would be affected. Diba? And then of course, register it with the BLR to make the contract bar rule operational. Okay. If you do not post your CBA, it's a fatal defect. Na violation due process. And who has the obligation to post the CBA? It is the employer's obligation. Siya may-ari ng premises. Diba? Just post a copy of it in 2 conspicuous places. Ayan. Then of course, what is the effect if the CBA is not registered with the BLR? The CBA remains valid and binding between the union and the employer. But it will not bar any petition for certification election. So in other words, kahit na may CBA kayo for 5 years, at any time si Union B, yung hindi nanalong union, may file a petition for certification election. Diba? So kaya importante na irehistro ang CBA sa Bureau of Labor Relations para yung contract bar rule will operate. The CBA as a contract will bar any petition for certification election within 5 years. Exception during the freedom period. Okay? Now, what about the automatic renewal clause? The automatic renewal clause means that when there is no new CBA, the old CBA is deemed renewed. Ayan, kaya deemed renewed ito mga kapatid at kapanalig sa pananampalataya. All terms and conditions are deemed renewed until a new agreement is arrived at. So kaya nga automatic renewal. It has always been the subject of a bar question. Nag-end yung CBA, wala tayong bagong CBA, sabi ni employer, yay, libre na ako. I will no longer give you the benefits under the CBA because it's already expired. We have no new CBA. Wrong. The old CBA is deemed renewed with all the terms and conditions. Okay? Lugyang union, lugyang employees. Bakit? 5 years na nakaraan, ganun pa rin yung benepisyo. Okay? Now, remember that the CBA has 2 lifetime. Hindi ito parang pusa na siyam ang lifetime. Ang CBA, 2 lang. On the representation issue, also known as political aspect. Political, bakit? Mag-aaway-aaway yung mga unions 5 years. On the economic side, 3 years. In other words, yung CBA ninyo on the 3rd year, pwede kayong makipag-negotiate kay employer kasi marami na nangyari sa loob ng 3 taon. Di ba? From 2017 up to 2020, isipin nyo ano mga nangyari sa inyo. Ang dami na naging abogado niyan. Kayo naman, next year na, sa 2022 na kayo magiging abogado. Kasi walay bar exam this year. Ha? At tama yung sinabi ni Associate Dean Elaine kanina na not earlier than February 2021. Ha? Kaya pati kami mga lecturers ngayon, hayahay ang buhay. Ha? Bakit? Hindi kami nagta-travel pero nakakamiss din yung mag-travel. Nami-miss ko magpunta dyan sa inyo, sa Cebu and some other parts of the country. So, you can renegotiate with, after 3 years. Mandatory ba yan? Bahala kayo. Kung ayaw nyo mag-negotiate, automatic renewal lang tayo. Okay. Now, a CBA was extended by Philippine Airlines and Palaya for 10 years. Sabi ng Korte Suprema in 2002, valid under the principle of inviolability of contracts. Diba? Contract is a meeting of minds between 2 parties whereby one on behalf of the other undertakes to do something or to render some service. There was meeting of the minds. O wala tayong pakialam dyan. 10 years, ano ho ang basis niyan sa batas? Sabi ng Korte Suprema, no, it cannot go beyond 5 years. On the 5th year, mag-expire yan, you have to renegotiate. Kung hindi nag-renegotiate, di automatic renewal. Diba? But it will expire. Walang forever kahit sa CBA. Okay. Now, what about the freedom period na kanina pa natin binabanggit? The freedom period is the 60-day period before the end of the 5-year period. Time period, no? So let's say, example, June 9, 2015, na take effect yung CBA ninyo. The third year would be 2018. Ang actual expiration date niya for 5 years, expired na tayo, June 9, 2020. So dapat ngayon, nag-renegotiate na tayo, no? Now, the economic provision expired on June 9, 2018 kasi 3 years lang. Kung nag-renegotiate kayo, well and good, the expiration would be up to June 9, 2020. It cannot extend. Unless wala kayo negotiation. Now, what about the freedom period? The freedom period is reckoned from 60 days before expiration. In other words, kung mag-expire yung ating CBA, June 9, 2020, ang freedom period ay from April 9, 2020 up to June 9, 2020. Eventually, June 9, April 9 is a holiday. No? At this time, double holiday yan. Okay. So what can be done during the freedom period? Number 1, mag-file kayo ng petition for certification election. Hindi kayo nag-file, nag-expire yung freedom period, wala na. Automatic renewal tayo. Okay? A labor union na affiliate ng isang federation may disaffiliate. But remember, if you are just a local chapter, when you disaffiliate, you lose your legal personality. Okay? Kasi ang legal personality ng isang affiliate or ng isang local chapter is dependent on the mother union or federation. Whereas you are an affiliate. Ang affiliate ay isang independent union na sumali sa federasyon. Okay? Pag independent union ka, sumali ka sa federasyon, ang tawag sa iyo ay affiliate. Nag-disaffiliate ka, ay di may legal personality ka pa rin because you are registered independently. Okay. So any petition filed before or after the 60-day period shall outright be dismissed. Why? Tapos na yung freedom period. Hindi pa nag-start yung freedom period. Di-dismiss yan ng BLR kung nakarehistro sa BLR ang inyong collective bargaining agreement. Okay? So, ito ay itinanong na minsan, pero hindi madalas. Automatic retroaction. Mahirap-hirap kasi intindihin. So, pay attention. So, CBA expired on June 9, 2018. 3 years. Nagkaroon tayo ng bagong negotiation. The parties agreed to have a 20 pesos per day wage increase. 20 pesos per day. Ano mabibili niyan? Corneto. Mahal na yata ang corneto ngayon. Anyway, so the agreement was finalized November 9, 2018. That's 5 months after expiration. The question is, when is the effectivity of the 20 pesos per day wage increase? The answer is June 10, 2018. So magkakaroon ka ng automatic retroaction. Any agreement concluded within 6 months after the expiration, the effectivity of which shall retroact to the day after the expiration. So June 9 nag-expire, ano yung next day? June 10. Yan ang effectivity. Kaya magkakaroon ka ng retroactive salary. Hindi radioactive, retroactive salary. Okay? Ayan. What if nag-expire yung CBA June 9, 2018? January na, 2019, wala pa tayong bagong agreement. So wala ng automatic retroaction. Okay. The last time it was asked was bar exam 2001. O yan. Kasi hindi sila nagkasundo. Alam nyo kasi, kapag ka natapos yung 6 months period, the effectivity of the new benefit could be agreed upon by the parties. Dito, hindi nag-agree yung parties. So where do you go? Di jurisdiction ito ng voluntary arbitrator. So you go to the voluntary arbitrator and then ask the arbitrator. So when is the effectivity of an arbitral award? It is the date set by the arbitrator. Sabi ni arbitrator, mag-retroact. Then the CBA shall retroact. Okay? Sabi ni arbitrator, huwag mag-retroact. So hindi magre-retroact yung provision, yung benefit. So what do you do? If you do not agree with the ruling of the voluntary arbitrator, the only recourse is appeal the decision of the voluntary arbitrator where, later on, we'll discuss that if you stay with me until 9 o'clock this evening. Wag, maglalaba pa ako Sabado ngayon. Anyway, substitutionary doctrine. Minsan, mahirap ang may substitute. No? Ayan. The substitutionary doctrine is a situation when the existing union loses its personality. Okay? And then, there's a union that substitutes. So, kaya nga substitutionary doctrine. When does it happen? Okay? Ito yung tanong ng 2009 bar exam. In the law on labor relations, the substitutionary doctrine prohibits a new collective bargaining agent from repudiating an existing collective bargaining agreement. True or false? Ako, mga estudyante, sanay sa true or false na exam. Sabi nga ni sir, true or false naman na walang true. Ako, syempre, parang pag true lahat yan, hindi na kayo mag-isip. Okay. Under the substitutionary doctrine, ganito ang nangyari. Union X is the existing collective bargaining agent in Company B. So may CBA sila, syempre. Now, on the second year, Union Z filed a petition for cancellation. Sabi lang, teka, kala ko ba hindi madi-disturb because of the contract bar? No, he's not disturbing the CBA. Kaya lang, pinapakansela niya ang legal personality ni Union X. It has nothing to do with the CBA. Di ba? So legal personality, hindi niya po pwedeng collateral attack. He can only attack it directly by filing a petition for cancellation. Even if there's an existing CBA, yes. Kasi yung personalidad ng union na nakataya dito eh. Okay. Ngayon, BLR canceled the registration of Union X. And it has become final, meaning nakarating sa Supreme Court. It's a final judgment. So nabakante ngayon yung posisyon ni Union X. Di magkakaroon ka ng bagong eleksyon para may mag-substitute kay X. Kasi hindi po pwede na walang union nakausap ang management. It's hard to be alone. You need someone to talk to. Kaya yung mga na-lockdown na walang kasama ay doble ang pahirap niyan. Kung lagi namang kasama, nag-aaway naman kayo lagi, it's not you, it's me. Naku, delikado rin yan. Okay. Yan, marami daw kaso ng domestic violence. So far, hindi pa naman ako nabubugbog dito sa bahay. Ha? Pinapakain naman ako ng tama at maayos kasi I always invoke my right under the Geneva Convention that prisoners of war should be treated humanely and given adequate sustenance. Okay. Ayan. So in a certification election, Union Q won. Pwede siya na ngayon sa substitute kay X. Okay? Naku, alam nyo, sa algebra man o sa tunay na buhay, problema ang X. Ha? Kaya ingat kayo sa mga X na yan. Sabi nung isa, magaling ka ba sa algebra? Sabi doon sa babae, bakit? I'll ask you sana to replace my X without asking why. Okay? Sabi naman ng isa, I don't care about your X. I'll never ask why. For as long as I have you. Ayan. Okay. We have Q, not you, but Q. Okay, Q won. So, si Q nag-substitute. Siya na ngayon ang kakausap kay employer B, company B. Ngayon, may CBA pa. Union Q cannot repudiate. It cannot invalidate the existing CBA. But it may request the employer to shorten the lifetime of the existing CBA. Boss, 2 years pa o may 3 years pa natitira. Baka naman next year mag-bargain na tayo. Pwede yun under the substitutionary doctrine. Okay? Maliwanag, ha? Yan. Bawal mag-issue ng injunction ang regular court to stop the implementation of a CBA provision. There are 2 no injunction rules in the Labor Code. Article 126, the regular court cannot issue a TRO to stop the implementation of a wage order. Okay? Another no injunction rule, Article 266. But in Article 266, there is an exception. That's the case of Alagueña versus Philippine Airlines. What's that? Dito kasi, nagkaroon ng CBA yung FASAP, Flight Attendants and Steward Association of the Philippines. Ito yung mga flight attendants, no? Karoon ng CBA na yung mga babaeng flight attendants would retire at the age of 55. Male flight attendants would retire at the age of 60. Abe, nagulat yung mga babae. Alam nyo, under Philippine laws, women are overprotected. Diba? Sa dami ng batas for the protection of women. But wala pa pala tayo sa kalingkingan ng Israel, no? In Israel, women are always favored by the law. Maraming lalaki na kukulong on false allegation na ni-rape nila yung babae at hindi naman pala. Ang totoo pala, kabaliktaran. Okay. So maswerte pa tayo sa Pilipinas. Pero sa dami ng rights sa mga babae, ang dami ng gusto maging babae. Sabi nila, be proud, you are men. Why? The men of today will be the women of tomorrow. Anyway, so ito na. Ano ang dahilan kung bakit ireretiro nyo kami at the age of 55? Ano nagagawa ng mga lalaki at the age of 60 that women cannot do? There should be equality. Huh? Sabi ng mga lalaki, with all due respect, menopause na ho kayo. That's a fact of life. Totoo naman. So sabi ng mga babae, bakit kayo? Di ba? Kinapos na kayo. Okay. Ayan. Yan tayo eh. Okay. So, pa-i-implement na ngayon itong CBA provision na ito. Ang sabi ni Patricia Alagueña, hindi kami papayag. We would go to court. And they asked for an injunction. Makati Regional Trial Court Branch 147 issued an injunction stopping Philippine Airlines and FASAP from implementing the CBA. Sabi ng Palace na Court of Appeals, Your Honor, a regular court cannot stop us from doing this. There is no injunction rule in the Labor Code. The RTC, the regular court, is prohibited from issuing a TRO to stop a CBA provision from being implemented. Then, sabi ng Court of Appeals, o nga naman judge, may no injunction rule tayo. Di ka pwede mag-issue ng TRO. Okay. Ang sabi naman ng ni Patricia Alagueña, so of course, they went to the Supreme Court. Ang sabi ni Patricia and company, ang issue ko dito, hindi lamang yung no injunction rule, but the discrimination against women. Women should not be discriminated against because they are women. Nga nila, the best man for the job is a woman. Okay? Kasi signatory ang Pilipinas doon sa Convention for the Elimination of All Forms of Discrimination Against Women. Our Constitution and our laws are always for the protection of women. Di ba? Ayan. Okay. So kaya, hindi po pwede ito. At ang regular court is now given authority to issue injunction because the labor arbiter alone cannot resolve this issue because it requires the application of the Constitution and our commitment to the CEDAW Convention. Okay? Maliwanag ha? So talagang ang mga babae ngayon ay pinapaboran at meron ka pang Magna Carta of Women, ha? At meron ka pang violence against women and their children, and so on. Okay, so ano ba ang bargaining unit? A bargaining unit, well, to simplify, is a department in the employer's setup. No? So parang ito, sa eskwela, pinakamagandang setup. Na example, teaching personnel. So isang bargaining unit yan. The administrator, isang bargaining unit. Yung mga office personnel, isang bargaining unit. Ayan. So that's what we meant when we say bargaining unit. Okay. 2007 bar exam question, explain the Globe Doctrine. Naku, ito yung mabagal yung internet, katulad din ng PLDT at saka Smart. Ano? Okay, hindi ho. Ano ba ang Globe Doctrine? Ang Globe Doctrine ay galing doon sa isang American case, ha? Globe Machine Stamping Company, na if the employees belonging to different bargaining unit would want to be joined together under one union, so be it. Trip nila yun eh. Walang basagan ng trip. Okay? What about the community of interest rule? Kung pare-pareho kayo ng interest, dapat isang bargaining unit kayo. That's how you explain it. Diba? Okay. Now, ito na ngayon yung mga test to determine who are the employees in a bargaining unit. Okay? Kasi bawat bargaining unit must be represented by at least one union. Isang union lang talaga. Now, there are contending unions. That's the reason why magkakaroon kayo ng inter-union dispute. So ano yun? Certification election, consent election, run-off election, and so on. Okay. Now, eto na. Organized establishment tayo. Ha? So pag sinabing organized, there is a union operating. Pag walang union, unorganized. Pag disorganized, abay sarado na natin. May problema yan. Ha? Okay. So if it is organized, meaning may union na nag-exist, may CBA, mag-file tayo ng petition for certification election. Kailan natin gagawin? During the freedom period. We explained that. That's the 60-day period before the end of the 5 years. Now, yung petition ninyo, remember, caudal, must be supported by a written consent. So dapat yung petition may pirma. At least 25% of the members of the bargaining unit. Okay, kung may 100 kayong empleyado sa bargaining unit, dapat 25 nakapirma doon sa petition ninyo para magkaroon ng certification election. Okay, so what is a certification election? A certification election is a secret balloting. Okay, in which the employees in the bargaining unit will choose a union to represent them. Kasi not all of them can talk to the management. So they must have a representative. Okay. Now, so in order to win in a certification election, kailangan natin, kinahanglan na ang botohan na ay double majority. Double majority, ano yon? Ano ang first majority? Okay. Ang unang majority, let's say you have 100 employees. Okay? First majority is simple majority, meaning 50% plus 1. So anong 50% plus 1 yan? At least 51 employees must vote. Okay. Bumoto yung 51 employees. So nakuha mo na yung first majority. Ano yung second majority? Let us distribute. So Union A got 15 votes, Union B 9 votes, Union C 7 votes, no union, of course. No union is always a choice. In a certification, consent, or run-off, but not run-off. Consent or certification election, there is always no union because the right to join includes the right not to join a union. Okay? So, total natin, 51. Tama ba? 51, ha? Pasensya na. I hate numbers. Kaya ako nag-abugas siya. Anyway. Na ay winner? Oh, walay winner. Kasi nobody got a majority. So ano ang majority ng 51? It must be at least 26. Okay? Nobody got 26. So anong gagawin natin? Wala nakakuha ng second majority. Kung may nakakuha ng 26, yun na ang mananalo. Sabi ng estudyante ko, sir, paano kung naka-26 yung no union? May bargaining ba? Kung bargaining mo mukha mo, no union na eh. Hindi sir, no union yung pangalan ng union nila eh. Okay. Masaya yun, ano? No union, yung palang union. Okay? Walang nanalo. So, pildi ang tanan. Okay. Now, what if less than 51 yung bumoto? Hindi nakuha yung first majority. The election officer, also known as med-arbiter, would declare a failure of election. Not on account of force majeure, terrorism, or whatever, but for failure of the majority to cast their vote in a certification election or consent election. Okay, so what happens if there is failure of election declaration? So anyone can file a petition for certification election within 6 months from the declaration of failure of election. Okay? So within 6 months. Yan. Okay, so assuming nagkaroon ng botohan. Ha? So 100 bumoto, pero hindi tayo nakakuha, o nakuha natin yung first majority, but the second majority was not attained. Walang naka-26 doon sa example natin. So you will have a runoff election between the two unions who garnered the highest number of votes. Yung dalawang union na nakakuha ng pinakamataas na boto, iyan ay magkakaroon ng runoff, a return bout, parang Pacquiao Morales for the nth time. Ayan. Okay. So, what happens in a runoff election? Ito na mangyari. Two unions with the highest number of votes. So, ulitin natin yung example natin. 100 employees, bumoto ang 51, so there is no failure of election kasi first majority vote was acquired. Okay. Union A, 15, Union B, 9, and so on. So total 51 votes. Eh sino ngayon ang magra-run off? Ang magra-run off ay Union A and Union B. Teka muna, magpo-protesta yung mga no union. Eh kami ang mas mataas, 20. Hindi totoo yun. Kasi in a run-off election, no union is not a choice. Okay? Why? Kasi in a certification or consent election, in effect, parang ganito ang tanong. Do you want to have a union or not? If you want, which union? Okay? Eh kung gusto ng majority no union, eh di sana naka-26 yung no union. Eh di no union, masaya si employer. But since hindi naka-26, majority gusto ng union, the only thing to be decided is which union would represent the employees. So in a run-off election, no union is not a choice. Kasi nag-decide na ang majority that we want to have a union. Kinahanglan na a union. Okay? That's why there must be a union. No union is no longer a choice. But in a certification, consent election, no union is necessary. A choice. One of the choices. Okay? Diba? Well, even dismissed employees can also vote in a certification, consent, or run-off election, provided he is still questioning the legality of his dismissal. So may illegal dismissal case pa siya kasi wala pang finality. So he can still vote. Ayaw nga siya papasukin sa employer, kaya nga siya tinanggal. Pwede niya mag-insist. Okay? Now, what about consent election? In a consent election, you do not file a petition anymore. Gentleman's agreement o union ABC. Mag-consent election tayo. Kami, no union kami. Dilagay natin. So wala nang supervision ito ng BLR o ng regional office. Okay? But still, we have to respect the result. Now, what about a rerun? This is a new rule under Department Order number 40-1-15, Section 16. Okay? Dito, nagkaroon ng tie. In a consent election, run-off election, nagkaroon ng tie. So ang gagawin nyo, hindi na kayo mag-file ng petition. Within 10 days, after the posting of notice of tie, voting, magkakaroon ng rerun. It will be the med-arbiter or election officer who would schedule the rerun election. So mas madali. Hindi ka sa magpapile ng petition. Okay. Now, what about voluntary recognition? Repealed na ho ito. Okay? Kasi may mga employer na ayaw talagang mag-recognize ng union. Okay? So they do not want to recognize a union, kaya ang ginawa, ni-repeal na lang ito. Ang pinalit, ito, what if nag-iisa ka lang union na nag-ooperate? Ha? Wala other unions. Ha? There's just a single union operating. Hindi ka na magpaparecognize kay employer. Under the new rules, you go to the regional office or to the BLR, as the case may be, and ask for a certification that you are the sole exclusive bargaining agent. So ang tawag natin dyan, CEBA. Okay? And you cannot bargain with the employer. Paliwanag, ha? Yan. Wala nang... Ngayon, nagkaroon ng certification election, may nanalo si Union A. So within 1 year, no one is allowed to file a petition for certification election. Okay? And then, nagde-negotiate kayo sila. So while negotiation is ongoing, hindi na kayo pinapayagan na mag-file ng petition for certification election. Nagtapos na yung 1 year. Opo, hindi na pwede. Okay? Deadlock. Nagkaroon ng deadlock in the negotiation, bawal din mag-file yung rival union ng another petition. Ang problema, pag nag-deadlock yan, magkakaroon kayo ng voluntary arbitration. In voluntary arbitration, minsan hindi nagkakasundo, you have to appeal to the Court of Appeals. So pag nag-appeal kayo, hindi rin pwede mag-file ng petition for certification election because of the appeal bar rule. So ang daming bar rule, ano? Now, the employer cannot participate in any manner kasi meron tayong tinatawag na bystander rule. Okay? Ang role lang niya, i-inform siya na petition has been filed at hingian siya ng listahan ng mga qualified employees who are to vote. Okay? That's also the ruling of the Supreme Court, no? In 2009, Santa Lucia East versus Secretary of Labor. And then of course, syempre, pag may nanalong union, may hindi nanalo, ang tawag dinaya, o file ka ng appeal. From the decision, kasi ang nag-conduct ng election, yung med-arbiter. So when you want to appeal the decision of the med-arbiter, hindi na sa Bureau of Labor Relations, you go to the Secretary of Labor within 10 calendar days. Okay? Then from the Secretary of Labor, file a petition for certiorari. Court of Appeals ka na. That's why motion for reconsideration ka na. Now, so we'll proceed to grievance machinery and then voluntary arbitration. What is a grievance? Simple lang ang grievance. It's any question by the union or the employer concerning interpretation of the CBA. Interpretation, enforcement of company personnel policy. No work, no pay. Hindi ka nag-agree. Yan. Company personnel policy yan. So, what do we do? Yan. Dapat magkaroon kayo ng grievance machinery. That's in the CBA. Pag wala kayong grievance machinery sa CBA, you have to establish a grievance committee. Iba yung kumita sa committee. Committee lang ito, hindi kumita. Composed of at least 2 representatives from the employer, 2 representatives from the union. Kasi numbers game yan. Okay. So you have to submit all grievances to the grievance machinery or grievance committee. Now, the role of the grievance committee is to resolve all grievances within 7 calendar days. If they remain unresolved, they shall automatically be referred to the voluntary arbitrators or panel of voluntary arbitrators. Okay? So yan. So 2017 bar examination question, state the jurisdiction of voluntary arbitrator or panel of voluntary arbitrators. Pag isa lang, edi voluntary arbitrator. Pag marami, edi panel of voluntary arbitrators. Okay. So ang jurisdiction nila, all unresolved grievances, syempre, under the CBA and interpretation of company personnel policy. So yan yung ating mga jurisdiction. Now, pagka ang violation ng CBA ay gross violation, hindi akin yung picture, pasensya na, nanggaling sa Google yan. Okay. Ang gross violation ng CBA ay flagrant or malicious refusal to comply with the economic provisions. In other words, after 3 years, ayaw mo pa rin magbigay ng mga benefits, baka gross violation na yan. So gross violation of the CBA is unfair labor practice. You do not submit gross violation of the CBA to the voluntary arbitrators. Where do you go? since it is ULP, jurisdiction belongs to the labor arbiter. Okay? Exclusive original yan. But make sure that the violation is not just simple violation, but a gross violation of the CBA, so that the labor arbiter would acquire jurisdiction. Liwanag, ha? Okay. Now, the voluntary arbitrators have other jurisdiction. Ito yan. Wage distortion arising from the implementation of a wage order. Under Article 124 of your Labor Code, balikan ninyo, 124 of the Labor Code, anong sabi dyan? Wage distortion is a situation wherein there is an increase in the minimum wage that results in the elimination or severe contraction of intentional wage differentiation among hierarchy of employees in the same employer. So pag kayo ay organized, it is under the jurisdiction of the grievance machinery and voluntary arbitrator. Yung mga inyong productivity incentive bonus o yung profit sharing, ayan, diyan din yan sa voluntary arbitrator. Okay. So, puntahan natin ng arbitrator. So, arbitrator is expected to decide, etc. Parang judge yan, no? Now, you have voluntary arbitration. A voluntary arbitration is a settlement of labor management dispute. You do not go to court, kayo na lang ang nag-decide. Okay, sino ang voluntary arbitrator? Ito, magaling na arbitrator yan si Ed Caluwag. Sabi niya, nagpunta ako dito hindi para makipag-away. Ganyan ang arbitrator, hindi nang aaway. Okay, ang voluntary arbitrator ay dalawa. Either he is accredited by the board, and we are talking of the NCMB, National Conciliation Mediation Board. Okay? Or siya ay accredited or siya ay chosen by the parties. Hindi siya accredited, pero yung employer at yung union, siya ang gustong arbitrator, then he can be a voluntary arbitrator. Okay? Ilagay nyo lang sa inyong CBA. Now, a voluntary arbitrator is not an employee of the government. Hindi siya empleyado ng Department of Labor. Pero binabayaran yan ng mga parties. Ha? What about a compulsory arbitrator? Ang compulsory arbitration is mandated by law. So ang compulsory arbitrator ay maaring labor arbiter, the regional director, the secretary of labor, the BLR, the NLRC. Sino ang mga compulsory arbitrators? Okay? That's why ang voluntary arbitrators may have jurisdiction other labor disputes. So ano mga other labor disputes na ito? Like for example, illegal dismissal. But you have to make sure na nakalagay sa CBA ninyo that the voluntary arbitrator has jurisdiction over your illegal dismissal cases. Otherwise, wala siyang jurisdiction dyan. Diba? Kasi it should be expressly stipulated by the parties in their CBA. Okay, now let us move on to the procedure. To guide you. Kapag galing kayo, ito, tingnan natin ito para mas mapabilis. No? So nag-file ng grievance ang labor or management. Kanino natin i-file ito at di sila nagkasundo, you file it with the grievance machinery or grievance committee, whichever. Now, the grievance machinery or grievance committee has 7 calendar days to resolve the dispute. If it is unresolved within 7 days or yung parties gusto mag-apila, you go to the voluntary arbitrators. Okay? Under the law, the voluntary arbitrator must decide within 20 calendar days. Ayan. So, pagka nagdesisyon ng voluntary arbitrator, you have 10 calendar days to file your motion for reconsideration. Ang sabi ng implementing rules ng Labor Code, no MR will be allowed. Kaya lang noong 2018, nagkaroon ng kaso, let me just show you the case of Guagua National College, no? Yan. Guagua National College versus Court of Appeals, na yung 10-day period daw na ito, that's the time you file a motion for reconsideration. Teka, sabi ng implementing rules, walang motion for reconsideration. It's the Supreme Court speaking. So pagka Supreme Court na nagsabi, wala na tayong choice. You have to comply. Okay? So yung 10 calendar days, you file a motion for reconsideration sa desisyon ng voluntary arbitrator. Okay? Kasi pag hindi ka nag-file ng MR, final and executory yan. So, nag-file ka ng motion for reconsideration, na-dismiss or na-deny. Then, you now have the chance to go to the Court of Appeals. But this time, ang gagamitin mo ay Rule 43 of the Rules of Court. Hindi naman kasama sa amendment yan. Hanggang Rule 35 lang ang na-amend. So Rule 43 will be your basis. You file an appeal to the Court of Appeals. Then, from the Court of Appeals, Rule 45 ka na lang going to the Supreme Court. And the Supreme Court, again, has 24 months to resolve the issue. So yan, picturean ninyo para maalala ninyo. That is the process for voluntary arbitration under the Labor Code. Now, ito na yung Guagua National College. Okay na tayo dyan. Do not use Rule 65. What is Rule 65? Special Civil Action on Certiorari. You cannot use it. Okay? Kasi meron kang remedy of appeal under Rule 43. That's the reason why you cannot use it. Okay? Pag ginamit mo yan, pagagalitan ka ng Supreme Court. Ha? Ayan. Pero si Richard Gomez, hindi na pagalitan. Nag-drawing siya nito. Okay. So, and then you have the National Conciliation Mediation Board. Okay. At hindi pwede mag-issue ng injunction ang NCMB. So, another important issue, okay lang ba sa inyo? Mag-extend tayo mga around 10 to 15 minutes? Okay? So, silence means yes? Okay, so we can extend.
Yes po, of course.
Okay, thank you. Okay, so strike, picketing, and lockout. Now, puntahan natin yung strike. Ano ba ang purpose ng strike? Nasabi natin, strike is a powerful weapon para makumpel natin ang employer to talk to the union. Diba? Kasi otherwise, itong employer na to hindi makikipag-usap sa'yo pag hindi mo tinakot eh. Ganyan sa Pilipinas, minsan takutan eh. Di ba? Okay. So natakot si employer kasi pag nag-strike, walang magtatrabaho, walang kita. Okay. Now, there are forms of strikes. You have economic strike. You have ULP strike for obvious reasons. You have legal strike and illegal strike, syempre. You have slowdown strike. Take note, slowdown strike is not really a strike. What is it? The employee still reports for work. Kasi strike, di ka na magre-report eh. The employee still reports for work. But he sits down. He does not do anything. Illegal yan. Okay? And then of course, quickie strike. Sabi ng estudyante ko, sir, ilang oras ba ang quickie? Aba, malay ko. So ang quickie strike, an announced temporary stoppage. By the way, how do we define a strike? Strike is a temporary stoppage of work caused by the workers due to a labor dispute. So temporary stoppage of work caused by the workers due to a labor dispute. Bakit temporary? Eh mariresolve din naman yan eh. Okay. Wildcat. Nako, hindi akin itong librong ito ha. Nobody wants to play with. Anyway. Ang wildcat strike ay dineklara yung strike without the consent of the majority. Remember, dapat may consent ang majority. Okay. Then of course, sit-down strike. Sit-down strike, katulad ng slowdown, you go to work, doon sa slowdown, you slow down the production. Sa sit-down strike, you do not do anything. So parehong illegal yan. Okay? And then, you have sympathy strike. Ito, nakasimpatya ka lang. Wala namang employer-employee relationship. Simply because kaibigan ng presidente nyo, yung presidente ng union doon sa kabilang kumpanya, naki-strike din kayo. Illegal yan. Okay. So 2017 bar exam question number 17. Ito ba, pwede ba mag-strike ang mga PhilHealth employees? Ang PhilHealth employees ay hindi pwede mag-strike kasi meron silang charter, no? Merong created by a charter, GOCC yan, with original charter. Therefore, PhilHealth is covered by the Civil Service Law. The employees cannot have their strike. Okay? So that's how you should answer that bar question in 2017. So what are the requisites for a valid strike? Ito palagi natin itinatanong eh. Okay, number 1, you must have a valid ground. So what are the valid grounds for a strike? Tatlo lang naman yan. Bargaining deadlock, of course you know that. Unfair labor practice and union busting. Okay, we'll explain union busting later on. Ano ba ang union busting? Ito, tinatanggal mo yung mga officers of the union. So the survival of the union is at stake. Strike na kayo. Okay? Yan ang union busting. Ha? Now, Number 2 requirement, notice of strike. Saan ka mag-notify? Ito, papasok na ngayon yung NCMB, National Conciliation Mediation Board. If the ground for your strike is bargaining deadlock or economic grounds, file a notice 30 days before your intended date of strike. Okay? Pag unfair labor practice, 15 days before your intended date of strike. Now, pag union busting, no need to file a notice. Pero, hindi pwede mag-strike agad. We will observe the 7-day strike ban. Okay? Paliwanag tayo, iba ang treatment ng batas pag union busting. Kasi yung life ng union itself is at stake. Diba? So kapag buhay mo na nakataya, anong gagawin mo? Kailangan mo na i-depensa ang sarili mo. So self-defense is allowed. Okay? Kaya nga yung mga police justified pagka may nanlaban. Diba? Parang na-overuse yung nanlaban. Kaya ako ayoko manlaban. Okay. So cooling off period. Ano ba yung cooling off period? That's the third mandatory requirement. Syempre, mag-sweetheart. Mainit ng pareho. It's not you. It's me. Ay, cool off muna tayo. Nag-cool off. Sa cool off, naghahanap ng solusyon. Hindi naghahanap ng iba. Kasi pag naghanap ka ng iba, magkakaproblema tayo lalo. Diba? So in a cooling off period, we are looking for a solution. Not looking for someone else. Okay. Bagay, sabi lang, ano yan? Walang matatag na relasyon kung tikim lang ang intensyon. Anyway, hindi naman, wala naman daw relasyon mapuputol kung sa tukso hindi ka papatol. Kaya matutong mag-control at hindi tikim ng lahat ng sampol. Anyway, so cooling off period. Kapag ka ito ay economic strike, nag-notify ka sa NCMB, 30 days, yun ang cooling off period mo. Pagka ito ay ULP, nag-notify ka sa NCMB, 15 days, cooling off period. Pag union busting, no cooling off period is required. Okay, pwede ka mag-strike, pero may strike ban. Okay, ano ang purpose ng cooling off period? Dito na papasok ng NCMB. Pag-uusapin kayo. Baka naman may di kayo pinagkakasunduan, baka pwede kayo magkasundo. Okay? That's the purpose. Hindi talaga nagkasundo. Mainit talaga ang mga ulo. Ito na naman papasok Iba ang hinahanap di ba? Kaya hindi ka talaga maigo. Okay. So, sabi ng Korte Suprema, in that case of 1982 pa ito, no? Pero still applicable at hindi pa yan i-reverse ng Korte Suprema, nag-lapse yung cooling off period. Wala talaga So anong gagawin natin? Kunin na ninyo yung strike vote. But then again, you can get the strike vote within reasonable time kahit hindi pa tapos ang cooling off period. Okay? 30 days yan. For example, ito ay bargaining deadlock. You have 30 days. So what will you do with 30 days? Quarantine? Hindi. So you have to talk to each other. Talk to your employer. It is facilitated by the NCMB. Mag-usap kayo, baka hindi lang kayo pinagkakasunduan. Kasi behind every angry woman daw stands a man who has absolutely no idea what he did wrong. Okay, joke lang. Kasi nung unang panahon daw, women have no rights. Eventually, women would have some rights. But nowadays, women are always right. Kaya nga ito, I do not know if you have experienced this, with all due respect to the ladies, if you respect them. Kaya lang, pagka married kayo o may girlfriend kayo, ang pakikipagtalo sa girlfriend o sa asawa parang pagtaya sa loto. Bakit daw? Ang hirap manalo Okay? Hindi ka talaga mananalo dyan. Okay, so gather all the members. Okay? And then get the strike vote. Ano ba yung strike vote? Agree ba kayo na mag-strike tayo? Okay? Secret balloting yan para walang impluensya. Ngayon, nakuha yung strike vote. I-report natin ito sa NCMB. And from the time na ni-report ninyo yung strike vote, you cannot have your valid strike within 7 days. That's what we call strike ban. Okay? So, nireport natin yung strike vote. Majority po ng mga empleyado na miyembro namin gusto mag-strike. Ito na ang report namin. From that time, you count 7 days. Bawal mag-strike. That's what you call strike ban. Okay. So, ano ang purpose ng strike ban? Sabi ng Korte Suprema, para ma-ascertain natin na walang nag-exert ng undue influence doon sa mga employees para sila ay mag-strike. Okay? Ayan. Pasensya na kayo kung kayo inaantok kasi ang apelyido ko sa Bisaya ay talagang aantokin kayo. Pero hopefully, why maduka, ha? Okay. Ayan. Ngayon, baka naman nagkadayaan lang. Baka itong si presidente namin dinaya yung resulta. So that's the time for the NCMB to ascertain whether the voting was done voluntarily and no coercion. Okay. So tanong, kailan natin kukunin ang strike vote? The law did not say when exactly to get the strike vote. Kaya ang sabi ng Korte Suprema, 2 cases yan, National Federation of Sugar Workers versus Obejera, yan sa Negros yan, Occidental. No? Ang sabi, you can get the strike ban at any time, even within the cooling off period. But you still comply with the 7-day strike ban. You get the strike vote within the cooling off period, but still comply with the strike ban. Yan din ang sabi ng Coca-Cola Bottlers Workers Union. Diba? You may take the strike vote and report the same within the cooling off period. But again, kahit ni-report mo siya on the 25th day, pag natapos yung 30th day, may 7 days ka pang i-observe para makapag-comply ka. Okay? That is your strike ban. Okay? Maliwanag? Ayun. Okay. So all of these requirements are mandatory. When the union does not comply with the mandatory requirements, then the strike becomes illegal, and you know the consequences of an illegal strike, diba? Dismissal of employees who are officers, but the members of the union may not be dismissed simply because they joined an illegal strike. They can only be dismissed if they committed illegal activities in the conduct of that strike. Okay, so maintain a skeletal force. Nauuso ngayon yung skeletal force. Sabi ng Supreme Court, skeleton force ang ginamit nila, no? O ayan. So hindi naman ibig sabihin palalabasin yung mga kalansay, ha? Ito ay sa mga medical institutions. There was a report na diya sa Cebu, na maximize na raw yung capacity ng mga hospitals because of COVID cases. So let us hope and pray na matapos na ang COVID na ito. Pero pansin nyo ba na mga government officials hindi masyado nagkakaroon ng COVID? Kasi magagaling sila maghugas ng kamay. Okay? So kaya panatilihin maghuhugas ng kamay para magka-COVID. Ha? Okay. So yan. At yung mga single daw, hindi magkakaroon ng COVID kasi wala naman nag-stay sa kanila. I do not know. Narinig ko lang ho ito. Pasensya na. Okay. Ayan. So ngayon, the Secretary of Labor may assume jurisdiction. Ha? May assume jurisdiction. Okay? If there is a strike or an impending strike or lockout in an industry indispensable to national interest, the Secretary of Labor and Employment may assume jurisdiction and resolve the dispute or certify the dispute to the Commission. So in other words, pag dinesisyonan ito ng Secretary of Labor, ang next recourse ninyo is to go up to the Court of Appeals. Pero pag sinertify niya sa NLRC, you follow the procedure of the NLRC and then saka pa lang kayo pupunta sa Court of Appeals. Diba? Okay, so kahit na wala siyang separate return to work order, the employees, pag nagkaroon sila ng notice of assumption of jurisdiction, automatic, they have to go back to work. Otherwise, the strike becomes illegal. Now, even the President of the Republic may assume jurisdiction over a strike or lockout. Okay? Now, ano ang epekto? Ayan, all the striking or lockout employees must go back to work. Paano lockout ho? The employer must readmit all lockout employees. Okay? So hindi kailangan na i-notify ka na mag-a-assume siya ng jurisdiction. Why? The basis of assumption of jurisdiction is police power, as what we have discussed in the opening discussion. Okay? So police power is the basis. Now, what about a lockout? Lockout is the temporary refusal of the employer to furnish work. Okay? Temporary refusal. Bakit? Matatapos din naman yan. To furnish work, si employer naman, because of a labor dispute. Bakit lockout? Kasi pinalabas muna yung mga empleyado bago inilock yung gate. Kasi kung nasa loob at saka nilock, ay lock in. Serious illegal detention tayo dyan. Ha? Ay, hindi. Mag-take effect na pala yung anti-terrorism law. Within 24 days, pwede na. Kahit na walang warrant. Ano? Anyway, that's the beauty of the law under Section 29. You may want to read it. No? Okay. Hindi naman na bago. So, lockout, kailangan may mga requirements din. So, you should have valid grounds. Ano yan? So pagka ito, ang dalawa lang ang valid grounds ng lockout. Bargaining deadlock at saka unfair labor practice because even the union may commit unfair labor practice. Okay? So ngayon, anong problema natin? Wala ditong union busting. Kasi there is no union. Ang employer wala namang union yan. Di ba? Okay, so no union busting for ground of your lockout. Then, may cooling off period. Ay, nag-cool off na pala ito. Ayan din ang cooling off period. Ha? Walang kinalaman yung mga pictures dyan. Ha? Cooling off period, 30 days, 15 days. Ganun din. Kung ano yung requirements ng valid strike, yun din ang requirements ng valid lockout. You also get the cooling off period at dito pag-uusapin din kayo. No? And then, lockout vote. Sino naman ang boboto dito? All the members of the board of directors or board of trustees as the case may be. And then submit your lockout vote report to the NCMP and also observe the lockout ban, which is 7 days. So ang purpose naman ito, tingnan kung talagang botohan ng mga direktor ay valid at voluntary. Okay. Now, prohibited activities, these are purely reading matters, no? Bawal kayo mag-strike kung walang bargaining, obviously. Bawal harangan ng ingress at egress. Therefore, kahit nag-i-strike kayo, yung gustong pumasok, pwede pa rin papasukin. Ha? Hindi isinasara yung gate. Sa lockout, yun talaga, walang papasok kasi si employer ang nagsabi. Okay. Then, no violence shall be permitted. Okay. And then what about picketing? Ito, pag naduka ka na, mag-picketing ka na. Okay. Yung march to and fro, may mga placards na dala-dala. Ay, hindi akin yan, ha? Yung picture na galing sa Google yan, ha? Ayan, na mga isinisigaw yung kanilang mga hinaing. Okay, na ibigay ang ABS-CBN. Abay, maraming misis na natuwa na mawala ang ABS-CBN. Kasi yung mga mister, wala ng bisyo, alak, babae, sugal, cabaret, bar, nightclub. O, wala na. Natuwa. Kasi may GMA. GMA kami. Ano yun? Gentleman all the time. Okay. Then, punta na lang natin yung masyadong itinatanong pa. Ito, 2015 bar exam. Si George, an American, gusto niya magtrabaho as consultant in a tawag dito, IT company. So gusto niya rin sumama sa union. Pwede ba siya sumuporta sa union? Ang sagot ay nasa Codal Provision, Article 284. Aliens are not generally allowed to participate in union activities in the country. Exception if they have valid working permits. Kasi hindi ka pwede magtrabaho dito na walang permit, di ba? Yung mga pogo ba na yan? May permit ba yan? I do not know. Anyway, at saka dun yung principle of reciprocity that in the country of origin of that alien, Filipino workers are given the same rights. So yun ang requirement so that this American can support union activities in the country. Diba? O, Codal yan. If I remember my former professor, Attorney Sababan, na kinuha na ni Lord, do not go away from the Codal. You read the Codal because that is the way, the truth, and the life. Okay. Marami na akong mga professor ang namayapa na. At yung aming beloved Dean Riano, nandun na rin. So, buti na lang, may nauna ng labor lecturer doon. Kasi baka mag-bar exam din sila doon. Matagal-tagal pa tayo. Okay. Ayan. 2017. What are the accepted tests to determine the existence of employer-employee relationship? Yan, paulit-ulit na tinatanong sa bar yan. Ha? Okay? Yan ang accepted test. At according to the Supreme Court, the most important is control. Okay? Ano yung control? Hindi yung remote control, self-control, whatever control. Control is when the employer prescribes the manner, methods, and means by which the employee would carry out the task. Okay? Now, applying the test of employer-employee relationship, ito bang si Manong jeepney driver at yung kanyang operator, may employer-employee relationship ba sila? Abila, hindi boundary lang yan But according to the court, even if it is on a boundary system, there is employer-employee relationship between the jeepney driver and the operator. So kaya yung mga operator ngayon, mandated sila na bigyan ng ayuda, no? Ayuda, from the Spanish word, ayuda means help or aid. Diba? Sila dapat na magbigay. At huwag umasa sa DSWD kasi yung DSWD daw parang nag-iba yata ang meaning ng DSWD. Sorry sa mga taga-DSWD, you can confirm or deny naman. Ako narinig ko lang ito na DSWD daw ay Department of Selection and Wrongful Distribution. I do not know if that is true. Okay, so the employee has the constitutional and statutory right to security of tenure. And ano ba ang security of tenure? That the employee shall not be dismissed. Okay? Shall not terminate the employee. Not the employee, but the services of the employee. Kasi if you terminate the services of the employee, if you terminate the employee, the labor arbiter has no jurisdiction. It will be murder. So regular court tayo dyan. Ha? Terminate the employment, terminate the services. Okay. Kung napansin ninyo, there is no provision entitled illegal dismissal in the labor code. Okay? There is illegal dismissal if the employee's right to security of tenure is violated. So security of tenure is both a constitutional and statutory right. You can see in Article 294. So when the employee's right to security of tenure is violated, there you have illegal dismissal. Okay? And even probationary employees are entitled to security of tenure. So pwede rin siya mag-file ng illegal dismissal. Kung hindi pa tapos ang kanyang period of probation, tinanggal mo siya. So an employee has been illegally dismissed in violation of his right to security of tenure is entitled to reinstatement without loss of seniority rights. Itong palaging tinatanong sa akin, ano ba yung without loss of seniority rights? Yan kasi tinanggal mo yung empleyado, di ba? Illegal. And then, pinapa-reinstate siya ni arbiter after 1 year or 2 years. So what happens during the pendency of the case? Hindi na ba counted yun? Counted pa rin yun. Yan yung sinasabing without loss of seniority rights. So whatever benefits were given to the employees who were not dismissed should also be given to him because he was illegally dismissed. Okay? And full back wages. Now, ang full back wages natin, the latest of which, ang Philippine Journalists Incorporated versus Mosqueda, you have that in your screen, is from the time the employee's salary is withheld until reinstatement. Kasi pag ni-reinstate, edi susweldo na siya uli. If not reinstated, because there are employers who do not want to reinstate by any means, until finality of judgment. Okay? Walang deduction, walang qualification. So kaya pag alam ko na mananalo tayo hanggang sa Supreme Court, ayoko na siya ipa-reinstate. Bakit? Para mas malaki yung sharing. Kasi normally, sa labor, contingency tayo dyan kapag ang kliyente ninyo ay employees. Oo naman. Kasi nawala ng trabaho. Tapos kukuha ng abogado, pagbabayarin mo, susugal ka dyan. Diba? Okay. So ngayon, what if reversed by the court? Pag naging final yung reversal, tapos na doon yung computation of back wages. Ngayon, ni-reverse uli, di tatakbo uli. Kasi minsan, panalo sa arbiter, natalo sa NLRC, yung employee. Tapos umapila sa Court of Appeals, nanalo. O di takbo na naman uli dahil nanalo eh. Okay, so that's how you compute back wages. Now, there are instances, kilala nyo yung nasa picture na yan, he is now the President of the Philippines during his younger years. Award of separation pay in lieu of reinstatement. Normally, wala ito sa labor code. It is in jurisprudence. So pinapa-reinstate mo yung tao. Ang problema, hindi mo na ma-reinstate kasi old age. Pinapa-reinstate siya, pero 65 years old na pala. So we cannot reinstate him. So bayaran na lang natin siya ng separation pay. Iba pa yung back wages sa separation pay. Yung back wages kasi illegally dismissed siya. Yung separation pay, because you cannot reinstate him anymore. Okay? Ayan. Then, the position no longer exists. Baka puro sitting position, standing position siya dati. Then, it is taken over by another company. Or, insolvency. Ito yung, hindi yung mga batang ito na insolvent, naka-rugby kaya insolvent. Okay? And then of course, closure. Well, para mag-move on kayo, you have to have closure. And strained relations. Palaging ginagamit mga employer ang strained relations na ito eh. Ano ba yung strained relations? Ayan, hindi strained na by relations. Anyway, walang kinalaman yung picture. Under the doctrine of strained relations, you can no longer work in harmony with each other. Example, huwag magagalit yung mga CPA, ha? Ikaw ay accountant ng company. Siyempre, alam nyo, entrusted sa'yo lahat ng kanilang finances. Nawala yung tiwala sa'yo, tinanggal ka. Pinapa-reinstate ka ngayon. Do you think the employer would want to reinstate you as his accountant once more? I don't think so. So kaya, nasabi niya, strained relations. So hindi na kita i-reinstate. Bayaran na lang kita ng separation pay. How much is the separation pay? Sabi ng Korte Suprema since 2010, 1 month salary for every year of service. It's not in the labor code, it is just in jurisprudence. Okay, so what are the kinds of employees? Sabi ng Korte Suprema, there are 4 pero 5 ang inilista. Ayan. So you have that case of Misola versus New City Builders. Now, who is a regular employee? A regular employee has 2 kinds. 1, those who are engaged to perform activities which are necessary and desirable to the usual business or trade of the employer. Example, a private school teacher hired to teach on June 1. In June 1. On June 1, 2020, kung meron. On the first day the teacher started working, regular siya. Kasi she is performing activities which are necessary and desirable to the usual business or trade of the employer. A school can operate without a security guard. But a private school cannot operate without a teacher. Sige nga. Di ba? So regular siya. Problem is may kasunod yan, 296. Probationary period. Okay. Now, an employee may not be performing activities which are necessary or desirable, but he has been doing it for more than 1 year. Therefore, he becomes a regular employee also. Okay? Then, you have project employees. Okay? Ang project employee, ang importante dito, naka-fix yung project. Not necessarily the date. At normally, kita niyo yung mama dito, sa construction, di ba? You construct a building, that's our project. Natapos yung buong building, optional sa employer kung ililipat ka sa iba niyang project o hindi na. Kaya lang, there is a stringent requirement of notifying the employee, make it known to him na ang engagement mo is just for this project para hindi naman siya umaasa. Kasi may mga employer na paasa. Ay pagpaasa ka, marami nagkakasakit. Ang sakit, walay tambal. Anong sakit? UTI. Umibig tapos iniwan. Okay? Ayan. Umasa tapos inindyan. Okay. So ngayon, the repeated rehiring of project employee does not ipso facto make them regular employees. Construction company, contractor. Nagtayo ng isang building, tapos na yung building. Inilipat ka sa another building. Another building. So naka 4 years ka na. Naka-3 building in 4 years. Pang-5 building o pang-4 na building, ayaw na sa iyo ng employer. Pwede ka nang tanggalin because you're just a project employee. Okay? Yan. Pero dapat klaro yung mga stipulations na project lang talaga per project. So no matter how many projects, kung ayaw ka na niya sa susunod na project, hindi ka pwede mag-claim na ikaw ay illegally dismissed. What about seasonal employees? Ayan, sa mga taniman ng tubo or whatever, may season, malapit na ang Christmas season, Marco season, Jose Maria season, and so on. Seasonal, so pag wala yung season ng planting, tapos na, wala ka ng trabaho. No work, no pay na naman tayo. That's the danger. That's the problem. Okay? Then casual employee. Ay, walang kinalaman yung picture dyan. Ang ganda ng definition ng labor code kahit na Supreme Court. Casual employees are those who are not regular, who are not project. So ano sila? Casual. Buti na lang yung implementing rule sinabi na sila ay occasional lang. Okay? At hindi sila regular. So for example, hire mo lang siya ngayon para linisin yung garden mo. Kinabukasan, wala na ulit siyang trabaho. Super engagement. Okay? Ayan. Now, what about fixed term? Ito, ang sabi ng Korte Suprema, hindi nagdag ito. Fifth kind. Those hired for a definite period. Tulad nung yung isang malaking mall, hindi ko napapangalanan, 2 letra lang naman yan, S at saka M. Nag-hire siya ng maraming sales ladies, binigyan niya ng 4 months contract. Di fixed term yun. After 4 months, wala na siya. O, yan ang endo. Wala naman magagawa yung sales lady. Bakit? hindi siya naging regular. Kasi ang sabi ng labor code, magiging regular ka lang kung natapos mo yung 6 months period of probation. Take note, professors, instructors are not independent contractors. We are regular employees. Okay. Now, the probationary period under the labor code is 6 months. At ang 6 months na ito, from the time of engagement, no? Kaya lang, it can be longer than 6 months provided at the time of engagement sinabi mo sa kanya na mahaba ang probationary period natin dito so that the right to due process is not violated, na notify siya. Okay? Any employee na sinabi mo 6 months lang, o after 6 months, regular na yan. Ito kasi ang problema sa labor code. Mahirap i-distinguish yung regular sa permanent. Kasi may mga regular tulad ng teacher natin kanina. At the day he or she was hired, regular siya. Pero hindi siya permanent kasi probationary siya. After 6 months, na regular, permanent na siya. Kasi tapos na yung probationary period. Okay? Maliwanag tayo dito mga kapatid at kapanalig sa pananampalataya. Now, puntahan natin yung how to endo. Diba? Kasi ito ang problema eh. The answer is you amend Article 296 of the Labor Code and make it illegal to give an employment contract less than 6 months. What's the beauty of 6 months? Yung 6 months kasi ang standard ng Labor Code. Na pag lumagpas sa 6 months, pinagtrabaho mo pa rin, he becomes a regular or permanent employee na. Ang problema, yung sales lady natin kanina, binigyan lang natin ng 4 months contract. After 4 months, wala na, endo na siya. And she cannot go to the labor arbiter and file a case for illegal dismissal. Why? Nag-end yung contract niya eh. Diba? So, ganun kasimple ang pagtatapos ng endo. Kaya kung meron sa inyo ng mga congressman o senador o gusto mag-congressman o gusto mag-senador at seryoso kayong tapusin ang endo na yan, amend the labor code. Put a provision that would prohibit employers from giving a contract of employment less than 6 months. Kasi yan ang inaabuso. But mind you, ang pinaka-rampant, ang pinaka-notorious na nagbabiolate ng endo, ang gobyerno. Why? O sino sa inyo ang mga job order? Diba? 12 months lang ang maximum niyan. Yung iba dyan, job order, 10 years na, hindi pa nare-regular. Diba? So the government should also reform itself. Hindi lang yung private sector ang palaging tinitingnan. Now, probationary period for private school teachers ay 3 years. Ayan po. 3 years ay maximum. Okay? It could be less than 3 years. But the teaching must be satisfactory. That's the case of UST versus NLRC. Then you have the case of St. Mary's University versus NLRC. And the teacher must be full-time. At ang teacher na full-time in that case of UST versus NLRC is this. No? In total working day niya is devoted to the school, no other source of regular remuneration. That's the reason why ang mga teachers ay hindi, mga lawyers ay hindi nagiging full-time teacher. Kasi marami tayong racket. Ano? Ayan. Okay. Now, let us proceed doon sa dito, management prerogative. Okay na tayo dyan. But remember, management prerogative must not be abused according to the Supreme Court. So kahit na regular yung empleyado, permanent siya, the management has the right to penalize employees. Okay? So you can put him on preventive suspension. Remember, preventive suspension is not a penalty. It is an act of self-defense on the part of the employer to prevent the employee from further damaging the employer's interest or co-worker's interest. Okay, but you have to put him on preventive suspension no longer than 30 days. After that, illegal na yan, constructive dismissal na yan. Okay. Now, ito lang, importante lang ito. 297, termination for just causes. Remember, the employee is at fault. Okay? Serious misconduct, willful disobedience. Ayan. So, ang sabi ng Korte Suprema, para maging ground for dismissal, ang serious misconduct, it must be not trivial. Ano? Kasi daw, pagka trivial yan, okay. So, pagka trivial yung ground, dismissal may be 2 hours ay penalty. So may inquiry kanina na sinasabi, allowed ba yung endo? Allowed ho ang endo kasi wala namang prohibition. And remember, you go back to contracting and subcontracting. Article 106, 107, 108, 109, pinapayagan doon ang mga kontraktor na mag-supply ng worker provided meron silang number 1, capital. At ang capital natin, not less than 5 million paid up capital. And then, separate business at hindi related dun sa employer. At pangatlo, may guarantee of security of tenure. So nai-end yung contract ng contractor at hindi ng worker. Kaya lang yung example ko sa inyo kanina, yung sa kinuha siyang tawag dito, ginawa siyang sales lady nung mall, binigyan lang siya ng 4 months contract, legal po yun. Legal yun kasi wala namang prohibition. It is now governed by the law on contracts, particularly Article 1306 of the Civil Code, that the contracting parties may put stipulations, terms and conditions provided are not contrary to law. Is there a law prohibiting an employer from giving a contract of employment less than 6 months? There is no law that I could remember. So allowed siya kasi walang prohibition na magbigay siya ng employment contract less than 6 months. So what is the effect? Pag natapos yung 6 months, then wala na. Endo na yung employee. Hindi naman siya pwedeng mag-file ng illegal dismissal kasi nga nag-expire yung contract. So ang ground niya, not dismissal, but expiration of contract. And the contract is legal because there is no prohibition in law. Diba? So kaya yun yung pakiusap ko sa mga gusto mag-senador at congressman. Kung seryoso tayo, natapusin ang endo at hindi lamang lip service, you amend the labor code, particularly Article 296. Make it illegal for an employer to give a contract that is less than 4 months. 6 months dapat. At any rate, pagdating ng 6 months, i-evaluate mo naman siya. Pwede mo naman siyang tanggalin kung hindi talaga nag-qualify. Okay? Kaya lang papasok na naman dito, hindi ka talaga magiging sapat sa isang tao na ibang hinahanap. Ano? Okay. Gross and habitual neglect. And then you have, ayan. So ito yung mga grounds dito sa Article 297. Ano? And then, of course, pagdating doon sa Article 29, tingnan natin pa. Due to lack of time, puntahan natin yung abandonment. Abandonment is other causes analogous to the foregoing. That's letter E of Article 297. Analogous to what? It is analogous to gross and habitual neglect. Okay? So, in abandon niya, that's the case of Agabon versus NLRC. And then in 2017, you have the case of Claudia's Kitchen versus Tangin. Na para mapatunayan na inabandon talaga ng employee yung kanyang employment, padalan mo pa rin ng 2 notices. Okay? Dahil yan, ang sinasabi natin na failure to report, binigyan mo ng notice na mag-report ka. Hindi ka nag-report. Another notice would be sent. That for your failure to report despite notice, you have been deemed resigned. You have abandoned your work. Kasi pag isang notice lang, yan, that's the case of Agabon versus NLRC. You are violating due process. Diba? There are 2 notices required. Okay. And then, puntahan natin yung notice to sever employment, etc. Hearing. Hearing requirement, yung trial type hearing is not required. Sufficient na nabigyan mo siya ng notice. Pagpaliwanagin mo siya. Because to be heard does not mean verbal argumentation alone. Okay. Puntahan natin. The burden of proof, remember, is on the employer. It is enough for the employee to allege that he has been illegally dismissed. It is the burden of the employer to prove that the dismissal was with a cause and he observed due process. Okay. Yeah. Now, what about authorized causes? To distinguish this from just causes, the employee here is not at fault. It is the employer who provided the grounds for the dismissal. So installation of labor-saving device, redundancy, retrenchment to prevent losses, ito ang ginagamit ngayon ng maraming employer. Retrenchment to prevent losses, totoo naman. Justify ngayon ang retrenchment to prevent losses. There is no need for actual loss. In fact, marami nang may actual losses. Diba? So mag-close na sila. Kaya lang, ang kaibahan ng 297 sa 298, here, there is separation pay. In 297, there is no separation pay. Why? Crime does not pay. We do not reward employees for violating our rules. Okay? That's why here, the employee is not at fault. Meron siyang separation pay. So, but there are 2 notices also required. 1 notice to the Department of Labor para ma-ascertain ng Department of Labor, totoo ba na yung mga grounds for dismissal? And to the employee, para makamove on na siya. Diba? So ganyan yan, kapag aalis kayo, i-inform nyo yung tao para makamove on naman. So 2 notices pa rin ito. Okay. Now, may separation pay dito. Okay? So if your ground is labor-saving device or automation or redundancy, the work of 2 people can be done by just 1 person with the same efficiency, pay him 1 month's salary or at least 1 month's salary for every service, whichever is higher. Okay? So in other words, example natin, nakikita ninyo, 9 months siya, regular na siya kasi after 6 months tinanggal dahil nagka-COVID. Edi 1 month salary. Naka 4 years na siya. Biglang nagkaroon tulad ng mga establishment ngayon na nagsara. Na-establish lang siya 2016 o 4 years na yung empleyado, bigyan mo ng 4 months salary because that is higher than 1 month. Yan ang sinasabi na whichever is higher. Now, on the grounds of retrenchment and closure, nalulugi na eh. So 1 month salary or half month salary, whichever is higher. Okay? So, 9 months, 1 month salary. 4 years, naka 4 years siya, nag-closure o retrenchment to prevent losses. 2 months salary, 50% lang. Bakit? Maawa naman kayo. Kasi yung tao naman ay nalulugi na. Di ba? And take note, the employer may be justified not to pay separation pay if the ground for closure is serious business losses or financial reverses. So I think marami magno-notify sa Department of Labor ngayon na nalugi ho kami, wala kaming babayarang separation pay. That would be possible. Kasi nga, serious business losses. At marami nagkukonsulta sa atin, both employers and employees, ganyan ang problema. Unang tanong palagi, totoo po ba na no work, no pay? Totoo po yun. Totoo po ba na pwede kaming ilagay on floating status for 6 months? Totoo po yun. Yan ang sinasabi ng Article 302 o 301 ng ating Labor Code. Na you can put the employee on temporary cessation of operation. So yung empleyado nasa Navy muna. Bakit Navy? Floating muna siya. Okay? O ngayon, so isummarize natin para mas maintindihan natin. So in dismissing an employee, there must be cause, there must be due process, and you dismiss the employee. So if there is cause, you observe due process, notice and hearing yan, the dismissal becomes legal. If there is no cause, no due process, the dismissal is illegal. So what happens if there is illegal dismissal? The employee must be reinstated to his former position without loss of seniority rights, bayaran ng back wages, damages, and do not forget attorney's fees. Okay. Now, there is no cause, there is due process, it will not cure the defect of absence of cause. The dismissal remains illegal. Now, there is cause, whether just or authorized, but the employer failed to give 2 notices, failed to observe due process. What happens to the dismissal? It is not illegal, it's not legal either, it is ineffectual. Okay, so what is ineffectual dismissal? Okay, yan sa China, yan yung kainan niya nata yan. Okay, the failure to hear him before he is dismissed renders the termination without legal effect. It is ineffectual dismissal. De Jesus versus Aquino. Okay? Hindi mo siya ni-notify. So kaya huwag kayong aalis na walang paalam. Magpaalam para makamove on. Okay. Pagka nagkaroon ng ineffectual dismissal, no reinstatement, no separation pay. But the employer must pay nominal damages. Okay? Nominal damages. How much? It depends on the circumstances. Ayan. So ito yung distinction between 297 and 298, and I think we have already discussed that. Now, this is can be a ground for termination of employment. Yung tao nagkaroon ng, huwag naman sana, COVID. Pwede na ba natin siyang tanggalin? Ang sagot ay yung disease niya ba ay unlawful or prejudicial to the health of the co-workers. Siyempre, nakakahawa eh. So tatanggalin natin siya. Pero, babayaran ng separation pay at least 1 month salary or half month salary for every year of service, whichever is higher. And a fraction of more than 6 months is considered 1 year. Now, ito ang requirement according to the Supreme Court in 2014. Yung pangatlo ang importante. A competent public authority certifies that the disease cannot be cured within 6 months despite proper treatment or medical treatment. So kung mapapatunayan na yung COVID niya hindi gagaling within 6 months despite treatment, pwede na siyang tanggalin at babayaran ng separation pay. Diba? Okay. Now, syempre, ang employee, work from home. At yung employer naman, akala dahil work from home, nasa bahay ka, hindi ka natatraffic, you can work from sunrise to sundown. 24/7. Ay, hindi po totoo yun. Okay? Even if the employee is allowed to work from home, you have to guarantee the rights of the employees. And this right should not be violated. Number 1, the right to privacy. Diba? Kung sa tingin ng employee, makukompromise yung kanyang surroundings at sa ibang bahay pala siya naroroon, eh pwedeng hindi niya ipakita. Diba? Pangalawa, yung oras. Kung official time niya ay 8 to 5, he cannot be required to face the camera of his PC or laptop beyond 5 o'clock. Okay? Beyond that, ay required na mag-overtime pay tayo kahit na work from home tayo. O so na-stress na yung employee dahil pinagtatrabaho na siya hanggang alas 12 ng hating gabi. Dahil nasa bahay ka lang naman eh. Paano naman yung pagtulong natin? O, pwede na siya mag-resign. Okay? But make sure that you give at least 1 month in advance a written notice of resignation. It's not you, it's me. Okay? Pero, pwedeng hindi na magbigay ng notice. Under the following circumstances, under Article 300, serious insult. Ininsulto siya ng employer niya. Ano kasing serious insult siya? Tinawag daw siya, nakabuka siya ni John Lloyd Cruz. Na-insulto ka pa? Oo, kasi gusto niya kamuka siya ni Ellen Adarna. Okay. Inhuman unbearable treatment, commission of a crime, then of course, other causes analogous to the foregoing. Magbigay lang siya ng notice. Hindi na siya kailangan magbigay ng notice dito. He can leave anytime. Okay? Now, ito ang madalas na tinatanong ng mga employees. Hindi sa bar, but the employees. Hey, attorney, I've been working with my employer for 20 years now. Mayroon ba akong separation pay kapag ka nag-resign ako? The answer is, if it is voluntary resignation, no separation pay. Despite the length of your service to your employer. Okay? So yan. Ngayon, exception if there is such provision in the employment contract. Or it is a provision in the collective bargaining agreement or ito ay company policy. But in the absence of such, voluntary resignation does not deserve compensation from the employer. Okay? Finally, second to the last, retirement. Retirement, tapos prescription, then we are done. Okay? So retirement, ito po ay may mga requirements sa labor code. Remember that in private sector employment, retirement pay is paid by the employer. Okay? So the employee must be 60 years old up to 65. 65 is the mandatory retirement age. You cannot compel the employee to retire at 60 if he wants to work until 65. Okay? At nakapag-serve siya at least 5 years at entitled siya sa 1/2 month salary. And according to the Supreme Court, 1/2 month salary means 22.5 days. An employee who satisfies the requirements for retirement must be paid at least 22.5 days salary for every year of service. One-time payment lang naman yan. Yung 22.5 days, 15 days salary plus 2.5 days representing 1/12 of the 13th month pay. Bakit 1/12? 2.5. Kasi yung 1 dyan is 31 months is 30 days, di ba? Applying Article 13 of the Civil Code. So 30 divided by 12 will give you 2.54. Plus service incentive leave, 5 days under Article 96 of the Labor Code. Teka, yung service incentive leave mo, binayaran ko na yan every year. Kasama pa rin yan sa computation ng retirement pay. So unless you provide for a broader inclusion, sabi ng employer, sige, 30 days for every year of service, that's better. But it should not be lower than 22.5 days for every year of service. Okay. And the 15-day salary must be based on the latest salary. Okay. Now, for underground miners, 50 to 60. 60 ang compulsory at nakapag-serve ng 5 years. Bakit ganon? Kasi nga naman, alam nyo, underground or surface miners, umiilalim yan, hindi naaarawan. Pinagretiro natin ng 65. Namatay na 66. Pwede pa, balik na naman siya sa ilalim. Hindi na naman siya maarawan. So para matagal-tagal siya maarawan, 50, pwede ka na mag-retire. Hanggang 60 years old. Okay, same benefits. Take note. Yung mga taga Dumaguete, alam nyo itong siliman. So, pinagretiro yung empleyado at the age of 60. Sabi nung empleyado, gusto ko 65. You cannot compel an employee to retire at an age earlier than 65. In the case of Sarcado versus Uniform, dito naman to sa Araneta Center, nakalagay sa CBA nila na when you reach 60 years old, you will retire. Whether you like it or else. Sabi ng employee, gusto ko up to 65. Pinilit siya magretiro. Illegal dismissal yan. Okay? So you cannot compel an employee to retire at an early age than 65 if he or she does not want to. So 65, mandatory na yan. Okay? Ayan. Then, when the employee contributes for his retirement, before you compute the 22.5 days for every year of service, you have to deduct his contribution. Okay? Ito, may tanong lang po. Allowed ba ang school na subject to extend probationary period of full-time teacher for that reason, hindi pa natapos ang master's degree? Hindi po. Kung hindi tapos ang kanyang master's degree at tapos na ang probationary period, the school has no option but to dismiss the employee. Otherwise, irregular mo siya kahit walang master's degree. Okay? So I hope na-answer natin yung query na yan. Yan. Okay. Kasi, o nga naman, ang requirement master's degree ka bago ka i-regularize. Natapos na yung 3 years, hindi ka pa nare-regular, pwede ka bang tanggalin? Ang sagot, hindi na po pwedeng tanggalin kasi natapos na yung 3 years. Hindi nga siya nag-comply. Ba't di mo siya tinanggal? So in effect, papasok yung estopel. Stop ka na from dismissing the teacher. Natapos na yung 3-year period. Okay? Yan. So ngayon, Calyanta versus Carnation, lahat ng money claims sa labor code, 3 years. Pero pag illegal dismissal, 4 years ang prescriptive period. Why? Illegal dismissal is an injury to a right, sabi ng Victory Liner. Ito, isa sa mga naapektuhan ng COVID itong Victory Liner. Magle-lay off sila, magre-retrench ng around 600 employees. OMG. Sa dami na mawawalan trabaho. Okay? Ayan. So pagka illegal dismissal, that's an injury to a right. Therefore, ito ay magbe-prescribe in 4 years. That's the case of Calyanta versus Carnation. Okay. Then, ano ba yung injury to a right? An injury to a right, what right? Right to property. So, ang papasok na prescriptive period, not the labor code, but 1146 of the civil code. Okay? So, kaya, when you are illegal dismissed, your right to property is injured, then you have 4 years to seek redress. Okay. Now, pag pure money claims, ang mag-a-apply ay Article 306. Pure money claims. So, 3 years lamang. Hindi 1144, which is 10 years ang prescriptive period, or 1146 na 4 years ang prescriptive period, but 306. The prescriptive period of which ay 3 years. Now, tanong, what about OFWs? Ang sabi ng Korte Suprema, OFW does not become a regular employee no matter how long he serves the foreign principal. Okay? Therefore, pagka nag-file ng claim ang OFW, pure money claims. So the prescriptive period is just 3 years. Okay? Kasi money claims lang siya. So in case of conflict between a law of general application, like the Civil Code, and a law of special application or special law, like the Labor Code, dealing with the same subject matter, the special law prevails. So the Labor Code, in terms of prescription, prevails over the Civil Code. Pero pag money claims. So kaya nailusot yung illegal dismissal na 4-year Civil Code provision would apply because it is based on injury to a right, the right to property.